You screamed at a tow truck driver today. You were wrong. Here are 71 reasons why. Straight from the people who have heard every single version of your excuse. 1. You parked on a public street, so you have decided the public owns it, and therefore nobody can touch your car, and you are about to learn what public actually means in the most expensive vocabulary lesson of your adult life. Public roads are governed by municipal parking codes, and those codes have teeth. Sharp, expensive, hydraulic lift teeth that do not care about your theory of collective ownership. The legal authority to tow from a public street comes from state vehicle codes, and in California alone, Vehicle Code Section 22,651 gives law enforcement and authorized operators sweeping removal powers that were not written with your opinion in mind. Here is the distinction that is about to rearrange your worldview. Public means the public has the right to use the road, not the right to store private property on it indefinitely. Use and storage are two entirely different legal categories, and your car crossed from one into the other the moment it stopped moving. Street sweeping violations alone generate hundreds of thousands of tows every year in major American cities, and the street being public is precisely why the sweeper has the right of way and you do not. Abandoned vehicle statutes in most states authorize towing after 72 hours regardless of whether any signage is even present, which means a technically legal park can become a legal tow if you simply forget about it long enough. The driver did not write the law. The driver executed a work order that the law generated the moment your bumper crossed into the wrong zone. Yelling at the operator is the exact equivalent of screaming at the mail carrier for delivering a bill you did not want to open. The street belongs to everyone. That is exactly why it does not belong to you. 2. Your hazard lights are on, which means in your mind, you have activated a legally recognized force field that suspends every parking ordinance within a 30-foot radius of your vehicle while you run a quick errand that will absolutely not take more than 2 minutes. Hazard lights are defined in virtually every state vehicle code as a signal for a disabled or stopped vehicle in a genuine emergency situation, not a notification that you spotted a parking spot that technically does not exist and decided to invent one anyway. The average errand that begins with hazard lights flashing lasts between 11 and 14 minutes, according to urban traffic studies, which is long enough to block a fire lane, a bus stop, or a loading dock multiple times over, while you browse a snack aisle with the focused intensity of someone who has completely forgotten they are committing an ongoing traffic violation. No standing and no stopping zones explicitly override hazard light usage in most jurisdictions, meaning double yellow curbs, fire hydrant zones, and crosswalk clearance areas carry zero exceptions for blinking amber lights. In New York City alone, over 600,000 parking summonses are issued annually in fire hydrant zones, and a significant portion of those vehicles had hazards on, because the fire department has documented that blocked hydrant access costs critical minutes during active structure fires and is not moved by your aesthetic commitment to the four-way flasher. Tow operators dispatched under police authority have no legal obligation to wait for you to return. Once a vehicle is flagged for removal, the operator's liability window opens and the clock does not pause for the theatrical blink of your lights. Some municipalities have issued formal public communications specifically clarifying that hazard lights confer zero parking rights because drivers genuinely believed otherwise in numbers large enough to require an official statement. Your hazard lights are not a do not disturb sign. They are the equivalent of leaving your cart in the middle of the grocery aisle and expecting everyone to navigate around it because you tilted the handle slightly. 3. The moment you got your car back and noticed something that might be a scratch, you decided the tow driver did it, and you are preparing a lawsuit based entirely on the timeline of your feelings about when that mark appeared. Modern tow operators are trained, certified, and heavily incentivized to deliver vehicles in the exact condition they found them, and the scratch that materialized after the tow was almost certainly there before the operator ever looked at your door panel. Professional towing companies carry commercial liability insurance with per-vehicle coverage, and any legitimate damage claim gets investigated against a stack of evidence that begins with time-stamped, geotagged photographs taken before the vehicle was ever touched. The industry has progressively shifted to wheel lift and flatbed technology specifically because it eliminates the undercarriage contact that older chain and hook methods could occasionally cause, meaning the equipment being used on your car was engineered around the problem you are about to describe at full volume. Studies of vehicle damage claims filed against towing companies show that the majority involve either pre-existing damage the owner had simply never noticed before, or damage caused by the vehicle's own design. Low ground clearance, aftermarket body kits, cosmetic modifications, interacting with standard equipment in ways the owner never anticipated. Pre-tow photo documentation is now standard protocol at most professional operations, which means the operator arrived at your car with a camera and left with a contemporaneous record of every panel, every wheel, and every existing imperfection before the hook went on. Small claims courts dismiss towing damage cases with such regularity that judges in high-volume jurisdictions have developed a visible pattern of recognition the moment a plaintiff walks in with an after-tow scratch claim and no evidence of what the car looked like before. Blaming the tow driver for that door ding is like blaming the mechanic for the check engine light. They did not create the problem, they just got close enough to it for you to finally notice it exists. 4. You believe that basic human decency, common courtesy, or possibly an actual law requires a tow operator to give you a reasonable grace period before hooking your vehicle, because surely the system accounts for the fact that you were only gone a moment and you had every intention of coming right back. No state in the United States mandates a waiting period for tow operators once a valid removal order or parking violation has been identified. The concept of a grace period is entirely cultural mythology, built from the wish that consequences would wait politely in the lobby until you were ready to deal with them. Private property tows are governed by contracts between the property owner and the tow company, and those contracts typically authorize immediate removal the moment a violation is observed, with zero waiting room built into the language. Time-sensitive tow scenarios: a blocked fire lane, an obstructed loading dock during business hours, a vehicle sitting in an active bus stop, carry genuine operational and legal consequences for the businesses involved if enforcement is delayed, which is precisely why they contract for immediate removal in the first place. The claim that you were only gone a minute is functionally unverifiable from the operator's position. They have no way of knowing how long the car has been there, no way of knowing when or whether you plan to return, and no legal obligation to care about either question. In some high-turnover commercial zones, operators work under rolling patrol contracts that require continuous lot monitoring, meaning a car that appeared in violation on the current pass gets hooked regardless of when it arrived, because the interval between passes is not an authorized parking window. Police-initiated tows for traffic obstruction move even faster because the officer's priority is restoring traffic flow and not protecting the schedule of whoever parked there. Telling a tow driver you were only gone a minute is like telling a surgeon you needed one more day before the operation. The process started, the window closed. Your minute is their entire job description. 5. You are standing next to a sign right now, and your position is that the sign does not count because a branch was partially in front of it, or it looked faded, or you were approaching from the direction where it was technically behind you, and you have decided this observation is a legal defense rather than a description of how signs work in the physical world. The legal standard for signage in most jurisdictions is whether the sign was posted in a location where a reasonable person exercising ordinary attention would encounter it, which is a deliberately generous standard that does not require perfect sightlines under all possible weather conditions at every conceivable approach angle. Municipalities are required to maintain their signs, but maintenance failures are remedied through a city process, not by retroactively voiding enforcement authority for every vehicle caught while a work order is pending. Parking enforcement officers and tow operators in most cities photograph signage as part of their standard documentation package, creating a contemporaneous record of sign condition at the time of enforcement, which means the question of whether the sign was readable is not actually an open philosophical question anymore. Courts have consistently held that seasonal obstructions, overhanging foliage in summer, snow accumulation in winter, do not invalidate parking restrictions because the legal obligation to know local parking regulations rests with the driver, not with the sign's unobstructed visibility on any given Tuesday. The hidden sign appeal has a notoriously low success rate in administrative hearings, and cities track appeal outcomes with enough granularity to know that sign obstruction ranks among the least successful challenge categories precisely because the legal burden sits on the vehicle owner's side of the equation. The sign being behind a bush does not suspend the law any more than not seeing a speed limit sign suspends the speed limit. Ignorance of the rule and inability to see the reminder are two entirely different problems, and neither one gets you your car back for free. 6. Your vehicle is expensive, tasteful, and clearly communicates a level of sophistication that you feel should be reflected in who is permitted to touch it, and you would like the tow operator to acknowledge that their equipment is not rated for something of this caliber before they proceed with doing the job they have done approximately 10,000 times before your hood ornament showed up. Tow operators who work commercial lots and urban enforcement routes handle high-end vehicles on a routine basis, and your car's sticker price does not alter the physics of towing or the legal authority under which the tow is being conducted. Professional tow operators are licensed and trained under state-level requirements that apply uniformly regardless of vehicle value, and that certification does not have a luxury exception because the equipment does not need one. Flatbed transport, which is already the industry standard for low-clearance, high-value, or specialty vehicles, is specifically designed to eliminate rolling stress on drivetrains, differentials, and transmissions, meaning the premium handling method your manual recommends is also the method already being used. Many tow companies that service upscale commercial districts or valet operations maintain specialized equipment including soft straps, wheel nets, and low-profile dollies for exactly the vehicle category you are currently claiming requires special handling. A vehicle's market value does not grant its owner elevated legal status in a parking enforcement context, which means a vehicle worth $300,000 in a fire lane is removed under exactly the same authority as a vehicle worth $3,000 in the same fire lane because the fire lane does not have a price floor. Insurance coverage for towed vehicles in transit is a defined industry standard, and commercial operators carry cargo liability limits high enough to cover all but the most exotic machinery in production. Your car being expensive does not make the driver less qualified, it just makes you more theatrical about a process that was handled correctly before you arrive to supervise it. 7. You pay taxes and you have done the math in your head during this confrontation and concluded that your financial contribution to the public infrastructure gives you a proportional ownership claim over this specific rectangle of asphalt that supersedes whatever work order this operator is holding. Tax revenue is pooled and allocated through legislative budget processes, and no portion of your individual tax payment is earmarked for a specific section of road, let alone for your exclusive use of any part of it. The legal relationship between a taxpayer and public infrastructure is defined by public trust doctrine, which means the government holds roads in trust for the public's collective use and not for any individual's private benefit, which is a sentence that eliminates your argument before it fully leaves your mouth. Every other taxpayer on the same street has an equal theoretical claim under your logic, which means the argument, if it were valid, would give every citizen veto power over every other citizen's parking enforcement, creating a system so completely paralyzed it could not function for a single day. Property taxes, sales taxes, and fuel taxes collectively fund road systems, meaning renters, non-drivers, and commercial entities, who may never park on the street, also contributed to its construction, which makes your personal ownership argument uniquely selective about whose taxes count and whose do not. Courts have rejected tax-based ownership arguments in parking and towing disputes without exception, and there is no recorded precedent in American municipal law where a taxpayer successfully claimed a personal ownership interest in public road surface. The same argument applied consistently would give you a stake in the local courthouse, the municipal water treatment facility, and the public school gymnasium, and the right to park in all of them. You co-own a 1 in 300 million share of America's road system. Your individual cut of this parking spot works out to approximately the width of a human hair. The driver towed the other 299,999,999 shares. 8, you have decided that this entire operation is a scam, that the operator is a predatory actor running an extortion racket under false authority, and that calling it what it is, loudly, repeatedly, with escalating emphasis, constitutes a legal defense rather than a description of how you feel about being inconvenienced. Towing companies operate under state licensing, municipal contracts, and regulated fee schedules that are filed publicly, which is the exact opposite of how a scam is structured. Most states require towing companies to register their rate schedules with a state agency and post those rates publicly, and charging above the registered rate is itself a regulatory violation subject to fine and potential license revocation, meaning the fee you are calling extortion is a number someone approved in an official proceeding before your car was ever involved. Non-consent tows are among the most regulated transactions in the service industry precisely because of historical abuse, and most states enacted specific consumer protection statutes after documented predatory towing incidents in the 1990s and 2000s that look nothing like what is happening to you right now. Property owners who contract for lot enforcement must meet local signage requirements covering minimum sign size, placement height, letter dimensions, and required content before a tow company is even authorized to operate on that property, and failure to meet those requirements shifts liability to the property owner, not the driver. The vehicle owner has a statutory right to retrieve personal property from the vehicle at the impound lot without paying the tow fee in most states, a provision that exists specifically to prevent financial hostage situations and is definitionally incompatible with the extortion framework you are describing. Calling a tow a scam because you did not want to pay for it is like calling a speeding ticket a robbery because you did not want to slow down. The rules were posted, someone enforced them. Your feelings about the invoice are not a legal argument, and they have never been one. 9. You have announced that you are calling the police, and you are holding your phone at a meaningful angle while you do it, fully expecting that a squad car will materialize and instruct this operator to put your vehicle down and apologize for the inconvenience. In the majority of tow scenarios, the police are either the initiating authority or have no jurisdiction to override a lawful private property removal, which means you are either about to call the people who started this or about to call the people who cannot stop it, and neither outcome is going to result in what you are picturing. When a tow is police initiated, traffic obstruction, accident scene clearance, abandoned vehicle, the responding officers are the cops, which means calling for backup on a police-directed tow is asking the department to overrule itself, which departments do not do. In private property tows, officers typically cannot intervene to stop a removal that complies with state towing statutes and posted signage requirements, because their role is to keep the peace and not to adjudicate parking disputes in real time on behalf of whoever calls first. Police dispatchers in high-volume urban areas are trained to recognize calls about tow trucks, and will typically advise the caller that the matter is civil in nature and to contact the impound lot directly, meaning the unit you are expecting is not being rolled. The threat to call the police functions as a social escalation tactic that has been so thoroughly repeated in enforcement contexts that it has been stripped of all practical deterrent effect through sheer overuse. In documented cases where vehicle owners became physically obstructive while threatening to involve law enforcement, the owners themselves ended up cited for interference with a lawful business operation or obstruction, which is a plot twist that improves no one's afternoon. Threatening to call the cops on a tow driver is like threatening to call the referee on a penalty the referee already called. The flag is on the field, the whistle already blew. Your appeal process does not run through 911. 10. There is a person sitting in the passenger seat of your car, and you have determined that this biological fact constitutes an absolute legal barrier to the vehicle's removal. Because surely no one can tow a car while it is occupied by a living human being who is watching this unfold with increasing discomfort. Occupancy does not automatically grant immunity from towing, and the legal and safety analysis depends heavily on who is in the car, why the tow is being conducted, and what the operator's specific work order authorizes. Police-ordered tows of occupied vehicles occur in law enforcement contexts with regularity. 11. DUI checkpoints, traffic stop vehicle seizures, and arrest-related impounds all involve drivers or passengers who are present when the tow process begins, and the presence of those people has never been cited as a legal barrier to removal. For private property non-consent tows, most state statutes require the operator to stop if the registered owner appears and requests release prior to the vehicle leaving the property, but a person sitting in the passenger seat is not the same legal event as the registered owner asserting their statutory rights through the correct channel. A person who climbs into a vehicle specifically to impede a tow after the hookup process has already started may be interfering with a lawful business operation, which carries its own legal exposure that compounds rather than resolves the situation. The distinction between a tow in progress and a tow initiated matters legally. Once the vehicle has left the property or roadway, the removal is typically complete and the vehicle must be retrieved from the impound lot regardless of who was or is inside it. Operators are trained to verify that no one is inadvertently in a vehicle before completing a hookup, which is a standard safety check and not a legal obligation to stop if someone climbs in deliberately after the process has begun. Sitting in your car during a tow is not a legal strategy. It is a hostage situation where you are both the hostage and the person who drove to the location, chose to park there, and then decided to sit down. 11. You are operating under the belief that a tow requires your explicit consent to be legal because it involves your property, and surely anything involving your property requires your agreement before someone can act on it. Non-consent towing is a legally defined, extensively regulated category of service that exists precisely because owner consent is unavailable or legally irrelevant in enforcement contexts, and the name of the category tells you everything you need to know about how far your agreement matters here. The entire legal framework of non-consent towing is built on the state's police power to regulate road and property use. And if owner consent were required for removal, no parking enforcement action could ever result in a tow, which would make every posted parking restriction an unenforced suggestion rather than a rule. Every state has a non-consent towing statute that defines the conditions under which a vehicle may be removed without the owner's permission, who can authorize the removal, and what documentation is required. And those statutes have been on the books long enough to have been reviewed, challenged, and upheld multiple times in courts at every level. The consent framework in property law makes a careful distinction between a person's right to exclude others from their property and the government's rights to regulate use of public spaces and enforce private property rules on behalf of landowners who have specifically contracted for that enforcement. By parking in a posted no parking zone, a fire lane, or a private lot with towing notices, vehicle owners have constructively consented to enforcement. They have agreed, by choosing to park there, to the consequences that are plainly stated at the location. Tow operators working under property owner authorization are acting as agents of the property owner's legal right to control access to their own land, and that right does not require a separate conversation with every person who violates the terms of entry. Enforcement is not a service you ordered. It is a consequence you earned, and consequences have never required your signature before taking effect. 12. The car is registered to your partner, which you believe transfers all relevant authority to an absent third party, and leaves you with no obligations, and also, confusingly, the power to demand that the operator stop everything and wait while the situation sorts itself out through channels you have not fully thought through. The registered owner's identity determines who receives the statutory tow notification and affects the title record of the vehicle. It does not change the operator's authority to remove a vehicle from a location it should not be in, and it does not grant you emergency negotiating powers you would not otherwise have. The registered owner's information matters for the legal process of notifying the right person and processing the release, not for deciding in real time whether the tow proceeds, because that decision was made when the violation was identified and the work order was issued. In most states, anyone who pays the towing and storage fees can retrieve the vehicle from the impound lot, but identification requirements and release protocols are designed to prevent theft, not to give non-owners blocking authority over the tow itself. A non-owner in lawful possession of the vehicle can often demonstrate standing to claim the car through documentation of the owner's permission, but that is an impound lot administrative process that happens after the tow. It has no retroactive effect on whether the tow was lawful. The argument cuts both ways with particular force. If you are claiming the car has nothing to do with you because it is not in your name, you technically have no more standing to demand the tow be stopped than a random bystander who wandered into the situation. Operators are not required to pause the process while you call your partner, determine their availability, navigate the interpersonal dynamics of the situation, or wait for a text back that may not come in time. Telling a tow driver the car is in your partner's name is not a trump card. It is a confession that you are driving a car you cannot legally claim while demanding authority you do not actually have. 13. You went inside, you were gone for an amount of time, you are now characterizing as negligible. The operator saw you go in, and your position is that the act of witnessing your entry created an obligation to wait indefinitely for your exit. Because surely that is how human decency works in a commercial parking enforcement context. Observation of your entry creates zero legal obligation for the operator to delay enforcement, and the knowledge that you just went in is not a mitigating legal factor. It is simply information the operator noted while completing the task they were contracted to perform. Tow operators under lot enforcement contracts are typically paid per tow, which means intentional delay would be financial self-sabotage. But more importantly, property owners contract for consistent enforcement and not for selective enforcement filtered through whoever most recently walked through a visible door. The 5-minute claim is almost universally subjective and unverifiable from the operator's position, and experience in high violation commercial areas teaches quickly that 5 minutes is a unit of time that expands to fill whatever space the errand actually requires. Some municipalities and states do have provisions requiring a chalk mark or notice on the vehicle before initiating certain non-consent tows. But these are codified rules with specific applicability. They are not universal courtesy norms derived from the operator having watched you enter a building. In fire lane and emergency access tows, which generate a disproportionate share of the "I just ran in" scenario, the hazard created by the parked vehicle is immediate and ongoing, and the urgency of the removal is not reduced by the driver's physical proximity to the car. Businesses near high enforcement lots report that customers who park in violation and run in create persistent conflicts between the business, the property manager, and the tow company precisely because intention does not eliminate violation. The operator watched you go in. They also watched the fire lane stay blocked, the posted sign stay visible, and the clock keep moving. You were the only one in that parking lot who thought time was standing still. 14. You have retrieved your car and conducted an inspection with the focused intensity of someone who has recently decided they are owed money, and you have identified marks on your wheels that you are confident were not there before the tow, despite not having documented the wheel condition before the tow or at any other point in recent memory. Modern towing equipment is specifically designed to interface with vehicle contact points without damaging wheels, and rim damage claims after tows are among the most frequently disputed and most thoroughly disproven categories of claim in the entire industry. Wheel lift tow trucks use rubber-coated cradles and padded contact points engineered specifically to grip the tire without touching the rim, and the equipment's entire engineering purpose is to prevent exactly the damage you are now describing from across the parking lot at increasing volume. Flatbed tows, the alternative method used for most non-emergency removals in urban markets, involve the vehicle being driven or winched onto a flat deck surface, meaning no hookup equipment contacts the wheels directly at any point during the process. Pre-tow photo documentation by professional operators routinely includes close-up images of all 4 wheels before the vehicle is moved, which exists specifically to defend against the claim you are currently constructing, and those images were taken while you were still inside doing whatever you went in to do. Aftermarket rims with low-profile tires present a genuine geometry consideration with certain equipment configurations, and reputable operators either select appropriate equipment or note the configuration before beginning, precisely to avoid the scenario you are now performing. Road rash, curb rash, and parking structure contact are the most common sources of actual rim damage in the real world, and all three occur in the normal course of driving and parking, which means the damage you have discovered has a much longer and more personal history than you are currently acknowledging. If your rims were perfect before the tow, the operator has photographs proving it. If they were not, you now have very expensive evidence of how you have been treating your wheels. Either way, the documentation is not running in your direction. 15. You have exhausted your arguments, you have not gotten the outcome you wanted, and you have arrived at your conclusion. This is harassment, it is targeted, it is deliberate, and you are going to sue. Legal harassment in a civil context requires showing that conduct was severe, pervasive, and directed at you because of a protected characteristic, which means race, gender, disability, national origin, and a defined list of similar categories, none of which include parked in the wrong spot more than once. Consistent enforcement of a standing rule is the definition of fair and equal application of that rule, which is the direct opposite of harassment, and characterizing it as harassment because you have experienced it more than once requires a theory of targeting that the consistent application of a parking rule does not support. The phrase, "I am going to sue," is the single most frequently uttered and least frequently executed threat in the towing industry. And operators who have worked enforcement routes for more than 6 months have been sued in the abstract dozens of times and in actual court rarely enough to count. Frivolous civil suits against tow companies and property owners do occur, and courts have imposed sanctions on plaintiffs who pursued claims without evidentiary basis, adding significant legal costs to the original tow fees in a direction that does not benefit the person who came in angry. The proper remedy for a disputed tow is an administrative hearing with the municipality for police-initiated tows, or a small claims filing for private property tows, both of which require evidence, not declarations of intent, made at escalating volume in a parking lot at an inconvenient hour. Property managers who receive harassment complaints tied to consistent parking enforcement are typically advised by counsel that uniform, documented enforcement is their strongest legal defense, which means your threat of a lawsuit often produces more documentation and more rigorous enforcement rather than less. Consistent enforcement is not harassment. It is a parking lot applying its own rules to the same car that keeps ignoring them. The only pattern here is yours, and it ends at the impound lot. 16. Your registration is expired, you know it is expired, but the car starts every time and runs beautifully, and you would like that mechanical reality to carry some weight in this conversation about why you should be allowed to drive and park it on public roads. Vehicle registration is a legal prerequisite for roadway use and not a mechanical certification, which means an expired registration does not describe how the engine performs. It describes the car's current legal status as an authorized user of public roads, and that status is currently not authorized, not renewed, and not your decision to waive. Registration systems serve multiple functions simultaneously: verifying insurance compliance, confirming ownership identity, generating road use fee revenue, and ensuring emissions compliance where applicable. And none of those functions have any relationship to whether the motor turns over when you hit the key. Expired registration is one of the most commonly cited grounds for police-initiated tows in urban enforcement, and officers running plates during routine patrol can identify registration status without ever stopping your vehicle, which means your parked car can trigger a removal process before any human interaction occurs. Many states have specific statutory authority for towing vehicles with registration expired beyond a defined threshold, typically 30, 60, or 90 days depending on jurisdiction, treating them as effectively abandoned for compliance purposes regardless of their mechanical condition. The argument that the car runs fine applies the wrong standard entirely, because mechanical fitness for road use is determined through safety inspections where those are required, not through the owner's personal assessment of their own vehicle delivered at the moment of consequence. Insurance coverage is tied to registration status in many states, meaning an expired registration may also mean voidable insurance coverage, which compounds your legal exposure significantly beyond the tow fee you are currently focused on. Registration renewal systems in all 50 states include grace periods, online options, and payment plans specifically designed to reduce the barrier to compliance. Your car running fine is irrelevant. A car with no plates runs fine too. Running and legal are two different things, and the operator only cares about one of them. 17. There was no warning notice left on your car, no chalk mark on your tire, no orange sticker on your windshield, and you believe that this absence represents a procedural failure that voids the tow entirely, because surely basic fairness requires that you receive written notice before someone acts on a posted parking rule you drove past on the way in. Warning notice requirements vary dramatically by jurisdiction and violation type, and many enforcement scenarios carry 0. Advance notice requirement. Because the posted parking sign is the notice, it has been the notice since it was installed, and it was the notice when you drove past it. In police-initiated tows for traffic hazards, abandoned vehicles, or enforcement seizures, no advance notice is required or legally expected anywhere in the country, because the authority to remove comes directly from the violation and not from a prior warning cycle designed to give you a chance to avoid the consequence. For private property tows, the posted signage required to meet specific content and placement standards including minimum size, letter height, tow company contact information, and mounting height is the legal equivalent of advance notice, and by parking in a lot with compliant signage, you have already received the notice you are claiming was absent. Some municipalities do require a chalk mark or notice affixed before initiating certain non-consent tows in specific circumstances, but these are jurisdiction-specific codified rules with defined applicability, not universal rights that exist everywhere by default. Fire lane violations, handicap zone violations, and emergency access blockages carry no notice requirement anywhere in the United States, because the urgency of the hazard is the reason for the removal, and waiting 24 hours for a warning cycle would eliminate the entire operational purpose of the restriction. The sign on the post that says "No parking, violators towed" is the warning. You walked past it. The driver did not need to leave a handwritten note underneath the sign that was already telling you exactly what the sign was already telling you. 18. You have a handicap placard hanging from your mirror, and you have parked in a fire lane, and you are looking at the tow operator with the expression of someone who cannot believe this misunderstanding is still happening when the solution is so obvious to you. Handicap placards grant access to designated accessible parking spaces and, in some jurisdictions, extended time limits in metered zones, and the list of what they grant access to ends there. They do not override fire lanes, no parking zones, loading zones, emergency access routes, or private property restrictions, because the legal framework behind the placard was not designed to do any of those things. The ADA accessibility provisions and federal regulations governing disabled parking placards are specifically designed to ensure that accessible spaces remain available for people who need them, not to create a universal parking exemption that allows placard holders to park anywhere they find convenient, which would defeat the accessibility purpose by removing all structure from the accommodation. Handicap placards are issued to qualified individuals and do not transfer their privileges to vehicles that individual is not occupying, which is why placard misuse, displaying a placard belonging to someone who is not present in the vehicle, is a separately enforceable violation with its own penalty schedule. Fire lanes, hydrant clearance zones, and emergency access routes are categorically excluded from handicap placard privileges in every state's vehicle code without exception, because the emergency access rationale is not a competing consideration to be weighed against the accommodation. It supersedes it entirely. The Government Accountability Office has investigated placard abuse and found significant misuse rates, leading to enforcement crackdowns in multiple major American cities, which is part of why enforcement of placard-related fire lane violations has become more rigorous rather than less. Private property owners enforce parking rules against vehicles displaying placards when those vehicles are in non-accessibility related violations because the placard is not a master key to every painted surface in a commercial lot. A handicap placard is a permission slip for accessible parking spaces. The fire lane does not care about your placard. It cares about the fire truck that needs to fit through it. 19. You drove past a sign that said "Tow Away Zone" and processed it as a warning rather than a declaration, the way some people read "wet paint" and decide to test the hypothesis personally, and now you are here explaining to an operator why the word "zone" softens the legal force of the word "tow." Tow-away zone signs are authorized under the Manual on Uniform Traffic Control Devices as regulatory signage, which puts them in the same legal weight category as stop signs, speed limit signs, and do not enter signs. Not the yellow diamond advisory signs that suggest you might want to consider slowing down, but the rectangular white signs that tell you what the law actually requires. The sign exists specifically because drivers kept disputing TOWs by claiming the restriction was not sufficiently clear, and tow-away zone was the explicit, unambiguous regulatory response to that argument, meaning the sign you are standing next to was designed to eliminate the conversation you are currently attempting to have. The distinction between a warning sign and a regulatory sign is defined by shape, color, and official designation, and courts have treated tow-away zone signage as self-explanatory notice of enforcement consequence, with no recorded history of a vehicle owner successfully arguing that the language was merely advisory. Emergency tow-away designations, temporary signs erected for parades, construction projects, or emergency access, carry the same enforcement weight as permanent signs and may be erected with as little as 24 hours of advance notice under local ordinances, meaning even signs that appeared recently carry full legal authority. The psychological tendency to treat explicit warnings as statistically unlikely is well documented in behavioral economics, which is precisely why the sign uses the word tow rather than fine, because someone, at some point, decided that only the most direct possible language had any chance of being taken seriously. Tow-away zone is the parking equivalent of wet paint. You touched it. Your hand is blue. The sign was not exaggerating. 20, your car is spotless. Your record is clean. You have never once received a parking citation in your entire driving life. And you would like that information to function as a mitigating factor that prompts the operator to recognize you as one of the good ones and release the vehicle as a professional courtesy extended to people who have earned it. Tow authority is violation-based and not history-based, which means the legal trigger for this removal is the current parking status of your vehicle, and that status either meets the criteria for removal or it does not. Your lifetime scorecard is not a variable in that equation and has never been included in any version of towing law in any jurisdiction. Tow operators and private lot enforcement have no access to state DMV driving records, traffic court histories, or citation databases, which means the claim of a perfect record is both completely unverifiable and operationally irrelevant to the work order they are executing. The first offense concept is occasionally codified in specific contexts, and some jurisdictions do waive certain fees for documented first-time violations, but those waivers apply through an administrative process at the municipal level, not through curbside appeals to the person holding the hook. Selective enforcement based on self-reported history would be both unworkable and legally problematic, because similarly situated violators treated differently based on unverifiable verbal claims raises equal protection questions that no tow company's legal counsel wants to answer. People who genuinely have no prior parking violations often park in violation precisely because they lack the practiced attention to violation risk that comes from having been caught before. The absence of prior tickets correlates with lower awareness of parking rules, not with a demonstrated commitment to following them. Your perfect record lives in the DMV system. The fire lane you parked in does not have a reader for it. 21. The lot you parked in was not a real road, it was just asphalt behind a strip mall, and you have determined that parking law is a roadway concept that does not extend into the private paved rectangles where businesses ask their customers to leave their cars while they spend money inside. Private parking lots are subject to a combination of state towing statutes, property owner authority, and traffic codes that extend to any area generally open to the public for vehicular traffic, and the phrase, "it's just a parking lot," fails on every legal level simultaneously rather than just one or two. Many states extend traffic law jurisdiction explicitly to any area generally open to the public for purposes of vehicular traffic, which includes shopping centers, restaurant lots, apartment complex parking, and hospital facilities, regardless of whether a private entity owns the land beneath the asphalt. Property owners have the independent right to establish and enforce conditions of use for their property, and a posted sign authorizing towing for violations is a valid contractual condition that visitors accept upon entry. Not a suggestion, not a threat, and not something that requires the lot to be a municipality before it takes effect. Fire codes, ADA requirements, and emergency access regulations apply to parking lots through building and safety codes, meaning fire lane violations in private lots carry the same enforcement authority as fire lane violations on public roads because the fire truck has the same dimensions in both locations. Slip and fall law, DUI enforcement, and hit and run statutes regularly apply in private parking lots, and courts have consistently extended legal frameworks into private lot settings when public interest is served. Which is a pattern so consistent it has long since become unremarkable. The logical extension of your theory would mean no traffic rules apply in malls, grocery stores, or airports, and the absurdity of that outcome disproves the premise faster than any statute could. The asphalt does not care what you call it. 22. You know the owner of this property, you have met them, you have been to their home, you have a relationship that you feel should translate into professional latitude for the people they have contracted to protect the very lot you are currently being removed from. The property owner authorized towing through a signed contract with a tow company, and operator instructions flow from that contract, not from real-time claims of social connection made by the person whose car is attached to a hook. Tow operators receive work orders and standing authorizations through contractual arrangements that do not include a list of people exempt from enforcement because managing informal exceptions is operationally impossible, legally messy, and directly contrary to the consistent enforcement the property owner paid for when they signed the contract. If the property owner wanted to create exemptions for specific individuals, the mechanism for that is a parking permit, a reserved space, or advance written notice to the tow company. Not an informal social claim delivered at the moment of consequence by the person most motivated to make it. Operators are specifically trained not to honor unverifiable claims of authorization because false claims are common and acting on them creates liability exposure if the claim proves false, which it frequently does. Which is why the training addresses it explicitly rather than leaving it to individual operator judgment. The operator cannot call the property owner mid-tow to verify every claim of personal connection, and even if they could, a verbal confirmation from someone claiming to be the owner does not override the signed enforcement contract that was executed through a formal business process. If the relationship is genuine, the property owner can contact the tow company after the fact to authorize a fee adjustment through the proper channel, and that process works. It just does not work in a parking lot at the moment of confrontation. Knowing the property owner is useful information for after the tow when you call them. Right now, all the operator has is a contract. 23. You are having a bad day. This has made it significantly worse, and you would like the operator to acknowledge that fact in a way that prompts them to stop what they are doing and give some weight to how this situation is landing for you emotionally. Tow operators are professionals executing work orders under legal authority, and the emotional impact of enforcement on the vehicle owner is a real thing that the operator is aware of and also completely unable to factor into whether the tow proceeds, because emotional impact has never appeared in any version of tow authorization law. Operators encounter emotional distress from vehicle owners on every single shift in this industry, and the job self-selects for people with a high tolerance for conflict and a clear understanding of the difference between someone being upset and someone having a legal right to override what is happening. The emotional severity of an inconvenience is not a legal standard in any enforcement framework. Courts do not ask whether the traffic citation ruined someone's afternoon before deciding its validity, and the tow equivalent works the same way. There is documented research on compassion fatigue in enforcement professions showing that repeated exposure to emotional appeals in adversarial contexts produces psychological detachment as a coping mechanism, which means operators who seem unmoved are not being cruel. They are managing an occupational mental health reality that comes with doing this work every day. The day ruination argument also misattributes the cause. The parking decision created the situation and the operator is responding to it, which means the emotional distress correctly assigned belongs to the choice and not to the consequence. Ironically, emotional escalation is one of the most reliable ways to ensure that an operator who might have exercised discretion decides not to. Because discretion is a professional favor that evaporates when the person receiving it becomes hostile. Asking a tow driver if they care that they are ruining your day is like asking the alarm clock if it cares that you wanted to sleep in. 24. The fee is outrageous. The number on the paperwork is offensive. The entire financial structure of this industry exists to extract money from people in distress, and you are prepared to use the word extortion loudly enough that it starts to sound like a legal argument rather than a description of how the invoice is making you feel. Towing and storage fees are regulated by state and local agencies, filed on public rate schedules, and reviewed against cost benchmarks before they are approved. And the fee you are calling extortion is a number that someone in an official proceeding signed off on before your car was ever part of the conversation. The actual cost structure of a non-consent tow includes operator wages, fuel costs that run between $40 and $80 per hook for a heavy wrecker, equipment depreciation on trucks that cost between $80,000 and $200,000 new, insurance premiums, impound lot lease costs in urban real estate markets, and administrative overhead, which together produce a margin on a standard tow that is narrower than the invoice suggests. After-hour storage fees exist because impound lots are real property, secured, fenced, insured, monitored facilities occupying land in urban markets where those costs are significant and real and do not pause because you discovered the tow late. The comparison to extortion fails the legal definition, which requires obtaining something of value through threats under color of false authority. And a tow fee is a legitimate service charge for a legal enforcement action conducted under documented authority, which is definitionally the opposite of false. States that have enacted tow fee caps have done so through deliberate regulatory processes and set those caps high enough to maintain a viable tow industry, because without functioning tow operators, parking enforcement collapses entirely and the problem becomes everyone's problem. Extortion is when someone takes your money with no legal right to it. This is a regulated fee schedule for a service performed under legal authority. Expensive, frustrating, and entirely legitimate can all be true at once. 25. You are pregnant, or you have a medical condition, or you have some documented health circumstance that you believe should function as a real-time verbal exemption from parking enforcement, and you are presenting it now as though the operator has the authority to evaluate it, honor it, and release your vehicle based on your word. Medical conditions affect eligibility for disabled parking placards through a formal administrative process, a state-issued determination made in advance, and they are not on-the-spot verbal exemptions that can be claimed at the moment of consequence from someone who has no ability to verify them and no legal authority to honor them, even if they could. The formal accommodation process for mobility-related medical needs is a state-issued disabled parking placard, which represents an advance administrative determination made by a qualified agency before any parking situation arises. The system is specifically designed to be front-end precisely to prevent the scenario where accommodation is demanded in the moment from someone without adjudicative authority. Pregnancy is not a qualifying condition for disabled parking privileges in any state's placard system, though many facilities offer designated expectant parent spaces as a voluntary courtesy, a private amenity and not a legal right, and one that does not extend to fire lanes regardless of how the amenity is labeled. Tow operators who encounter medical claims are trained to call emergency services if the situation appears to be a genuine health crisis, not to release the vehicle because the appropriate response to a medical emergency is medical assistance. And those are two entirely separate response systems for two entirely separate problems. Operators who release vehicles based on unverifiable personal declarations create documented patterns that property managers and municipalities respond to by tightening contract language to explicitly exclude discretionary stops, meaning one operator's compassion becomes every future driver's harder enforcement experience. Your medical situation deserves real accommodation, the kind a physician documents and a state agency formalizes on a placard. What it does not deserve is a stranger suspending the law because you told them to. 26. The signs in this lot are new. You can tell because they look new, and you have decided that new signs come with a grace period during which the rules they describe have not yet fully taken effect. And drivers who were accustomed to parking here cannot be held to a standard that was not posted when their habits formed. Signage requirements for tow authority in private lots include content, placement, height, and contact information standards defined by state statute. And meeting those standards validates enforcement immediately upon proper installation. There is no grace period built into the regulatory framework for drivers to transition their parking habits to the new reality. Many municipalities require advance notice before new temporary parking restrictions take effect, ranging from 24 to 72 hours for street-level restrictions, but permanent private property signs for lot enforcement typically take effect upon posting because the property owner's authority to establish conditions of use does not come with a public adjustment period. The legal standard is whether the sign was properly posted per local code at the time of the tow, not whether the driver had a chance to see the installation process or adjust behavior that was already in violation of the property owner's rights before the sign made it official. Challenges based on sign posting timing are legitimate when they reflect actual procedural violations, but they require evidence that the sign was installed within a prohibited advance notice window, not a general impression that the sign looks like it was installed recently. The practical difficulty of tracking when every parking sign in a commercial lot was installed makes this challenge nearly impossible to pursue without formal civil discovery proceedings, which cost significantly more than retrieving the vehicle from the impound lot through normal channels. If the sign was not legally posted long enough in advance, that is a real procedural argument with an evidence requirement and a hearing process. It is not a conversation for a parking lot. That sentence describes every item on this list. 27. Your friend parks here every day, has always parked here, has never had a problem, and you are presenting this third-party behavioral pattern as evidence that the location is effectively authorized, a kind of informal prescriptive easement established through the accumulated parking habits of one specific person whose experience you are citing as precedent. Enforcement patterns are a resource allocation exercise shaped by patrol frequency, staffing levels, and contract priorities, not by which violations are technically legal and not by any implicit promise made to individual drivers by the absence of a tow on any specific day. Property owners and municipalities increase enforcement in response to complaints, changes in lot usage, business needs, or new management decisions, which means a lot that tolerated informal parking for months can become actively enforced overnight with a single contract signing, and the prior tolerance is not a legal promise that runs with the land or the friendship. Estoppel, the legal doctrines that prevents a party from changing position after another party has relied on their prior conduct to their detriment, is an extremely high bar to meet under any circumstances and has never been successfully applied in a parking enforcement context in American case law, which is a research outcome that should concern you before you build a defense around it. The "my friend" qualifier weakens the argument further rather than strengthening it. The claim is that a third party's unpunished behavior on different days in a different vehicle creates rights for you today, which is not how legal reliance works in any framework. Tow companies that take on enforcement contracts for previously unenforced lots always experience a spike in owner complaints for exactly this reason, because prior tolerance is universally interpreted as permission, and that interpretation is always incorrect. Every speed trap has drivers who use that road for years before the enforcement started. I have never been caught before has never once made a citation disappear. 28. There is a child car seat in the back of your vehicle, and you are invoking its presence as though the combination of child safety equipment and your emotional delivery of that fact creates an absolute barrier to the vehicle's removal that no reasonable person could proceed past. The presence of personal property inside a towed vehicle, including child safety equipment, does not affect the legal authority to tow. But it does trigger your statutory right to retrieve personal belongings from the impound lot, which is a separate and fully protected right that exists in most states, regardless of whether the tow fee has been paid. Most states give vehicle owners the explicit statutory right to retrieve personal property from a towed vehicle during normal business hours without paying the full tow and storage fee, and child safety seats qualify as personal property under those statutes, which means the concern you are expressing is already addressed by a legal provision you were not aware of until this moment. The presence of personal items inside the vehicle, regardless of their nature, sentimental value, or practical importance, is not a recognized exception to towing authority anywhere in the United States, because the vehicle's contents and the vehicle's parking violation status are legally separate considerations that operate on separate tracks. Car seats, strollers, groceries, prescription medications, and work equipment are retrieved from impound lots daily by owners who arrive with identification and access. The items through the personal property retrieval process that already exists for exactly this scenario. Tow operators are occasionally offered items from inside the vehicle as informal consideration to stop a tow, a practice that creates liability for the operator and changes nothing about the work order and which operators recognize and decline. The baby seat is not a hostage, and the tow driver is not holding it for ransom. It is in the car is going to the lot, and you have a legal right to go get it. That is the system working exactly as designed, even when it does not feel that way. 29. You are standing in front of a sign that says Tow Away Zone, and your position has evolved. You accept that the sign exists, you accept that it uses the word tow, but you believe the zone designation refers to an area where towing is possible rather than an area where towing is actively and consistently enforced as a matter of operational practice. And you would like someone to confirm that distinction before anything else happens. There is no such distinction. Tow Away Zone is one of the most explicit enforcement designations in traffic signage, authorized under the Manual on Uniform Traffic Control Devices as regulatory language in the same category as stop signs and speed limit signs. Mandatory compliance indicators, not probability assessments about how often something might happen. The sign exists specifically because drivers repeatedly disputed TOWs by arguing that the restriction was not clearly stated, and regulatory agencies responded by creating signage language as direct and unambiguous as it is possible to make signage language in a standard font at a standard size on a standard post. Courts evaluating tow-away zone signage have consistently treated it as self-explanatory notice of enforcement consequence, and there is no recorded case history of a vehicle owner successfully arguing in any jurisdiction that the phrase was advisory rather than mandatory. Emergency tow-away designations, temporary signs erected for events, construction, or emergency vehicle access, carry identical enforcement weight to permanent signs and can be erected with as little as 24 hours of advance notice depending on local ordinance, meaning even recently posted signs carry full authority. The behavioral economics literature on explicit warning compliance documents a well-established human tendency to underestimate the probability of stated consequences, which is precisely why the sign uses the word tow rather than something softer. Because someone decided that only the most literal possible language had any realistic chance of being taken seriously by the population of drivers who would otherwise be having exactly this conversation. 30. You have a specific and creative theory about why your bumper sticker, your car's age, the neighborhood you are in, or some other characteristic about the vehicle or your identity caused you to be selected for a tow that other, more generic vehicles avoided, and you would like to explore that theory at length with this person who is currently operating a hydraulic lift, Private property tow operators do not select vehicles based on appearance. They patrol for vehicles that are not displaying valid permits or are positioned in restricted areas, and the selection criteria is spatial and regulatory, not visual. Which means your theory of targeting requires the operator to have noticed something about your car and made a decision based on it that the work order does not reflect. Equal protection claims in parking enforcement require showing both that you were singled out and that the singling out was based on a constitutionally protected characteristic, race, religion, national origin, and a defined list that does not include vehicle color, bumper sticker content, car brand, or aesthetic condition, regardless of how strongly you believe those factors were involved. Municipal enforcement officers who issue citations or initiate police tows are subject to civil rights law, and the remedy for documented discriminatory enforcement is a formal complaint to the relevant oversight agency, not a curbside argument with the person holding the hook who had no role in the decision you are describing. The frequency of non-discriminatory explanations for tows, wrong location, expired registration, fire lane, no permit, is so overwhelmingly higher than the frequency of documented discriminatory enforcement that administrative hearing officers encounter the targeting claim regularly and require evidence before treating it as anything other than a frustration response. If you believe your bumper sticker got you towed, consider how that argument sounds to a judge looking at a photograph of your car parked in a fire lane. The fire truck does not read bumper stickers either. 31. You have an offer. Cash, right now, directly to the operator. Whatever the fee is, just take it and put the car down and everyone walks away, and this whole situation gets resolved without anyone having to deal with the impound lot, and you cannot understand why this reasonable business proposition is being declined by the person whose job involves money changing hands. Accepting payment directly from a vehicle owner to release a vehicle mid-tow is explicitly illegal for the operator in most states. Not a discretionary choice, not a professional judgment call, but a regulatory prohibition that the operator did not write and cannot waive regardless of how reasonable your offer sounds from your position. Most state towing statutes define a specific legal category called a drop fee, the maximum charge an operator may collect if the vehicle owner appears during the hookup process before the vehicle leaves the property. And that is the legal mechanism for exactly this situation, administered through the company's billing system, not through a cash transaction between two individuals in a parking lot. Accepting cash outside the company's payment system exposes operators to charges of soliciting a kickback, violating their operator's license, or theft of services depending on the state's regulatory framework, which is a list of consequences that make your offer significantly less attractive from the operator's side of the equation. The amount you are offering is frequently lower than the actual legal drop fee, which means accepting it would not even make financial sense for the operator, even if it were entirely legal, which it is not. Property owners who contract for towing enforcement do so because they want violations cleared from their property, not because they want a revenue stream and an operator who accepts informal payments to not tow violating vehicles is failing the core service function they were contracted to perform. Offering to pay the tow driver directly is not a negotiation. It is an offer to bribe someone operating under a license dressed up as a practical solution. 32. This tow company should not be operating in your neighborhood. People around here do not want them here, and you are asserting a form of community territorial authority over which licensed businesses are permitted to perform enforcement functions in the geography where you happen to park your car. Tow companies are licensed by state agencies and contracted by property owners or municipalities, and neither the license nor the contract requires neighborhood approval, community board sign-off, or resident consensus before taking effect. The authority comes from the state and from the contracting party, and neither of those sources is a neighborhood. Municipal tow contracts are awarded through competitive bid processes managed by city procurement departments, and community input may inform policy through public comment periods and council meetings, but it does not veto individual operator selection or service area assignment through a parking lot declaration. The concept of towing rights as a community franchise reflects a misunderstanding of how professional licensing works. The state license applies wherever the operator is legally contracted to work, and it does not get subdivided by zip code or require local ratification to function in any specific area. Some cities do divide their geography into towing rotation zones for fairness among operators competing for police dispatch calls, which is an administrative scheduling mechanism designed to distribute business equitably among licensed companies, not a community authorization process requiring resident approval. Complaints about towing company operations in a specific area are directed to the relevant regulatory agency and, for municipal contracts, to the city department managing the contract. Channels that exist, that receive complaints, and that produce outcomes when the complaints are documented and factual. The tow driver's work order came from a contract, and the contract came from an authorized party, and neither of those sources needed your neighborhood's permission. Telling a licensed operator they have no right to be in your neighborhood is like telling a licensed electrician they cannot work on your block. The license does not come from the block. 33. You paid for parking through an app, you have the confirmation on your phone, the timestamp is right there, and you cannot understand why a valid digital payment receipt is not functioning as a universal authorization that covers your vehicle's current location and the full duration of your stay, regardless of what the physical signage in this area says. Parking apps are a payment mechanism, not a universal parking permit, and they can only authorize parking in the specific contracted spaces for which that app is the designated payment method. The confirmation you are holding proves that you paid, not that you parked in the right place, and those are two entirely different documents with two entirely different legal weights. A common source of app-related tow disputes is a driver who pays via app for one space, parks in a different space that is closer or more convenient, and is towed from the unauthorized space while holding a receipt for the authorized one they never actually used. A situation where every element of the payment transaction was completed correctly and the tow is still entirely valid. Paid meter time in municipally metered zones does not override posted clearance restrictions. A 2-hour paid meter space in a street sweeping corridor still gets towed during the sweeping window, regardless of how much time remains on the payment, because the sweeping restriction and the meter are two separate regulatory systems operating on the same piece of pavement. App receipts are admissible in administrative hearings for meter-related tow contests and have successfully supported contested claims. But the receipt must match the towed space, which is where the overwhelming majority of these claims fall apart when the hearing officer asks the one question that matters. The proliferation of parking apps has created a new category of confident confusion because a confirmation notification reads like permission when it is actually only confirming a financial transaction. Your receipt proves you paid for a space. It does not prove you were in it. 34. You parked on a residential street because the neighborhood feels quiet and personal, and not like the kind of place where enforcement happens to people. And you are expressing genuine surprise that residential areas have parking rules at all given how residential they seem. Residential parking enforcement is in many cities more actively managed than commercial enforcement, not less, through residential permit programs, street sweeping schedules, overnight parking restrictions, and complaint-based abandoned vehicle processes that generate significant tow volume from people who made exactly the assumption you are making right now. Residential parking permit programs exist in cities across the country specifically to restrict parking on residential streets to permit holders, and non-compliant vehicles are towed with a regularity that the residents who organized for the program specifically intended, because the program exists because non-residents were parking there without consequence and the residents wanted that to change. Street sweeping enforcement in residential areas is one of the highest volume tow generators in cities including Los Angeles and Chicago, where sweeping schedules are posted on every block and enforcement begins at the posted time without exception or sympathy for the driver who parked the night before without checking the sign. Overnight parking restrictions in snow emergency cities apply specifically to residential streets and authorize towing of non-compliant vehicles at the restriction hour, often 2 or 3 in the morning, because the city needs to clear routes before the morning commute and your vehicle's presence is the obstacle. Abandoned vehicle statutes apply in residential zones and are enforced through community complaint channels. A single neighbor report can trigger a 72-hour notice process that ends in a tow, and the vehicle does not need to look abandoned to qualify, just stationary for long enough. The neighborhood being quiet does not mean the rules are quieter. Residential streets do not get a different law. They get the same law with an even earlier street sweeping schedule. 35. You have never had a parking ticket in your life. Your record is spotless, and you are presenting this history as though it is a character reference that should prompt a professional courtesy from the operator, because people who follow the rules most of the time deserve some acknowledgement when they accidentally stop following them. Non-consent tow authority is violation-based and not history-based, which means the legal trigger for this removal is the current parking status of your vehicle in its current location, and your lifetime compliance record is not a variable the operator has access to, can verify, or is legally permitted to factor into the work order regardless of how impressively clean it actually is. Tow operators and private lot enforcement have no access to state DMV driving records, traffic court databases, or citation histories. The claim of a perfect record is both completely unverifiable at the point of contact and irrelevant to the enforcement action, even if it could be verified in real time. The first offense concept exists in some specific municipal frameworks where certain fees are waived for documented first-time violations, but those provisions operate through administrative hearing processes at the city level, not through curbside appeals to the person holding the hook who has no authority to waive anything. Selective enforcement based on self-reported compliance history would be both operationally unworkable and legally problematic, because treating similarly situated violators differently based on unverifiable verbal claims raises equal protection concerns that no tow company's legal department wants to manage as a recurring issue. People who genuinely have clean records sometimes park in violation precisely because their lack of prior consequences has produced a lower practical awareness of violation risk. The absence of tickets correlates more reliably with not having been caught yet than with a principled commitment to always reading the signs. Your perfect record is real, it is impressive, and it lives in the DMV system. The fire lane you parked in does not have a database connection. 36. You are offering to pay the operator directly right now in whatever form they prefer, and you are framing this as a streamlined resolution that eliminates paperwork and inconvenience for everyone involved. And you genuinely cannot tell whether the problem is the offer itself or the amount, so you are preparing to go higher. Accepting direct payment from a vehicle owner to release a vehicle is not a discretionary business decision the operator can make. It is a regulatory prohibition codified in most state towing statutes, which means the answer is no at every price point, and the number you are about to name will not change that. The legal mechanism for exactly the situation you are describing is the drop fee, a defined cap charge that the operator can collect if the vehicle owner appears during the hookup process before the vehicle leaves the property, and that charge is collected through the company's billing system with documentation, not through a cash transaction between two individuals making an informal arrangement in a commercial parking lot. Accepting money outside the company's payment system exposes the operator to charges that range from license violation to solicitation depending on the state's regulatory framework, which means your offer creates professional and legal risk for the operator at every denomination you're willing to consider. The amount being offered is frequently lower than the actual legal drop fee, which means the informal offer would not even make financial sense from the operator's position, even if it were entirely legal, and it is not. Property owners who contract for towing enforcement are paying for consistent removal of violating vehicles. And an operator who accepts informal payments to leave vehicles in place is failing the service function the contract describes, which is an employment problem that follows the operator back to the yard. Your offer is not a negotiation. It is an invitation for the operator to break the law in exchange for a sum that does not compensate for the consequences of breaking it. 37. Your car's market value is lower than the tow fee, and you have done the math. And your conclusion is that this mathematical relationship creates some kind of legal obligation running from the tow company toward you. A refund, a reduction, a moral acknowledgement that the numbers do not work in your favor and someone should account for that. towing and storage fees are service charges for specific actions performed, hookup, transport, and secure daily storage. And those services cost the same amount regardless of whether the vehicle being moved is worth $500 or $50,000, because the truck, the fuel, the operator, and the lot space cost the same either way. Vehicle owners whose accumulated tow and storage fees exceed their car's market value face a genuinely difficult situation that the industry calls a negative equity tow, and the legal remedy for that situation is not a refund. It is the option to abandon title to the vehicle through a formal process that releases the owner from further financial obligation while transferring the problem to the tow company. Most states have a statutory abandoned vehicle title process where an owner who does not retrieve a vehicle within a defined period loses title, and the tow company can pursue a lien sale to recover their costs from the vehicle's auction value, a process that caps the owner's exposure without creating any payment flowing back in the owner's direction. The lien sale mechanism is a consumer protection provision in that it ends the owner's ongoing storage fee, accumulation, and financial obligation, but it is not structured to produce a net payment to the owner because the owner's debt to the company for services rendered is the starting position of the entire calculation. Claiming the tow company owes you money because your car is not worth much inverts the financial relationship completely. You owe them for services rendered. The math just means your car has a problem, and that problem started before the hook went on. 38. The operator was rude to you, the tone was dismissive, the interaction was unpleasant, and you have decided that the quality of the customer service experience during the tow is legally connected to the validity of the tow itself, that sufficient rudeness delivered at sufficient volume can retroactively invalidate a work order. Operator conduct and tow authority are legally separate issues operating on entirely separate tracks, and a tow that was performed rudely is still a tow that was performed legally because the authority to remove the vehicle comes from the violation and the work order and not from the operator's bedside manner. Conduct complaints against tow operators are handled through the company's management structure, state licensing boards, and consumer protection agencies, all legitimate channels that produce real outcomes when the complaints are documented, and all of those channels are entirely separate from the process of contesting whether the tow was lawfully authorized. Administrative hearings for contested tows evaluate whether the vehicle was in violation, whether the tow was authorized, and whether procedural requirements were met. An operator tone during the removal is not among the factors any hearing officer is asked to weigh when determining those questions. Tow operators work in one of the highest conflict service environments of any licensed profession, encountering screaming, threats, physical aggression, and occasionally worse on a routine basis, which means evaluating rudeness in this context requires accounting for what the baseline provocation level looks like on a standard shift. States that license tow operators include conduct standards in their regulatory frameworks, and the remedy for a documented conduct violation is a licensing action against the operator, not a fee waiver, not a vehicle release, and not a retroactive change to the enforcement action that was already completed. If the person who served your eviction notice was rude about it, you are still evicted. Tone is a separate issue from authority, and the tow does not care how it was delivered. 39. It is a holiday, or it feels like one, or it is the kind of day that should carry the spirit of a holiday, even if it does not technically qualify, and you believe that this ambient sense of celebration or rest creates a pause in parking enforcement during which the normal rules are suspended out of shared civic goodwill. Parking enforcement on holidays is jurisdiction specific and almost never a blanket prohibition on anything. Meters may be suspended on designated holidays in some cities, street sweeping may be rescheduled, and some administrative offices may be closed, but fire lanes do not take federal holidays off, and neither does the tow company contracted to keep them clear. Many municipalities suspend meter enforcement on specific designated holidays, and that suspension applies only to the metered parking requirement. It does not extend to fire lane restrictions, no parking zones, permit zones, loading zones, or private property rules, because those restrictions exist independently of the meter payment system and are not administered by the same authority. Street sweeping enforcement is typically suspended on holidays when the sweeping schedule is also suspended, but that information is published in advance through the city's official schedule. It is not assumed by default on any day that feels festive, and the driver is responsible for consulting that schedule, rather than making an inference based on the calendar's emotional register. Private property tow enforcement operates entirely outside municipal holiday schedules, and a retail lot that contracts for continuous enforcement does not pause for any holiday that is not specified in the contract, because nothing in state towing law requires it to observe one. Police-initiated tows do not observe holidays either, because traffic hazards, DUI enforcement, and accident scene clearances occur on holidays at the same or higher rates than regular weekdays, driven by increased travel and event attendance. The fire hydrant does not take the day off, neither does the truck. 40. Construction was blocking your normal route, the designated lot was full, the detour signs were confusing, external circumstances combined in an unusual way that left you with no good option, and you ended up here, and you feel that the chain of inconveniences that preceded your parking decision should function as a mitigating narrative that softens the enforcement response. Construction-related parking displacement is a documented and extensively planned urban phenomenon. Projects that displace parking are typically required by municipal permit to provide replacement parking information, clearly marked detour routes, and in many cases temporary parking accommodations, meaning the inconvenience was anticipated and planned for by the permitting process before you encountered it. The necessity defense in a legal context requires demonstrating that the action taken was the only available option to prevent a greater harm, and I could not find a convenient spot does not approach that threshold in any jurisdiction because alternative legal options, transit, parking structures, adjacent streets, simply not going somewhere, are always theoretically available. Construction zone tows are among the most legally defensible category of removal because they are initiated at the request of a permitted construction operation with documented city authorization and signed contractor agreements that establish the tow authority before the first vehicle is ever removed. Temporary no parking zones erected for construction are required to meet the same advance notice standards as other parking restrictions, typically 24 to 72 hours of prior posting before enforcement begins, giving drivers notice before the restriction takes effect, even when the sign feels new. Regular commuters who lose established parking due to long-term construction projects are the most legitimate complainants in this category, and many cities have public communication systems and temporary permit programs specifically designed to address their situation through official channels rather than informal accommodation. Construction is inconvenient for everyone, including the operator navigating around orange barrels. Inconvenience does not create a parking space. It creates a harder problem that you chose the wrong solution for. 41. Your car is running, the engine is on, and you have determined that an idling vehicle is by definition in active use rather than parked, which means it cannot legally be considered abandoned, standing, or stationary in a way that triggers parking enforcement, because running and parked are mutually exclusive categories in your framework. Vehicle operation status is irrelevant to parking enforcement authority in every jurisdiction, and a running car in a fire lane is a fire lane violation, and a running car in a tow-away zone is a tow-away zone violation. And the engine's operational status changes neither the location of the vehicle nor the legal significance of that location. Most vehicle codes define parking and standing based on the vehicle's position relative to the roadway or restricted area, not the engine's operational status, and a vehicle stopped without an authorized driver present is parked for enforcement purposes, whether it is idling, silent, or somewhere in between. Police initiate tows of running vehicles regularly in DUI enforcement, where the ignition is on, the vehicle is in park, the driver is being detained, and the running engine has never been cited in any of those cases as a barrier to removal because the law does not include engine status as a relevant variable. The argument that a running car cannot be parked was specifically evaluated and rejected in multiple municipal appeals cases where drivers left vehicles idling in restricted zones and returned to find them towed. Courts consistently held that the presence of an idling engine did not alter the parking status of the vehicle or the authority to remove it. Leaving a vehicle running and unattended is itself a separate traffic violation in many jurisdictions under anti-idling laws and vehicle theft prevention statutes, meaning the running car may be accumulating violations rather than creating an exemption from them. A running car in the wrong place is still in the wrong place. Your engine being on does not reclassify your location. 42. You served in the military, or you are a first responder, or you have a professional background that involves public service, and you are invoking that history now in a parking lot because you believe it should generate a form of professional deference that causes the operator to pause the enforcement action as a gesture of respect. Service history deserves genuine acknowledgement, and it is also entirely separate from parking law, and there is no federal or state statute granting veterans or first responders as a Class A parking exemption beyond those specifically tied to documented disability status processed through the formal placard system. Federal law does not create parking exemptions for military veterans as a general category. Disabled veterans may qualify for disabled parking placards through a separate administrative process that confers specific, limited privileges in specific defined locations, not universal parking immunity that can be verbally activated at any moment of conflict. Active duty military personnel have legal protections under the Service Members Civil Relief Act, but those protections address financial contracts, lease obligations, and civil proceedings, not parking restrictions or tow fees, because the act was designed to protect service members from civil consequences of deployment, not from the consequences of parking in a fire lane. First responders in marked vehicles responding to active calls receive professional courtesies from tow operators based on informal industry norms and practical awareness of what an emergency vehicle needs. But those courtesies apply to on-duty professional operations and do not extend to off-duty personal vehicles parked in violation in commercial lots. Tow operators who are themselves veterans, a significant demographic in the industry, report that invoking shared service as a towing defense is particularly frustrating to encounter because it uses identity as a leverage tool rather than as genuine acknowledgement of shared experience. Service to your country is real and it matters enormously. It does not move your car out of the fire lane. Those are two completely separate things, and the fire lane has never once saluted anyone. 43. Your car is at an impound lot that is across town, and you feel that the distance between where the vehicle was towed from and where it ended up constitutes either a procedural violation or at minimum grounds for a fee reduction, because surely there is a closer lot and you should not have to travel this far to retrieve a vehicle that was taken without your consent. Impound lot assignment is governed by municipal contracts, operator licensing agreements, and logistical availability at the time of the tow, not by proximity to the tow location, and the requirement that you retrieve your vehicle from a specific facility is a function of how the operator's business is geographically structured, not a punitive decision made about your specific case. Police-initiated tow programs in major cities operate under rotation contracts that assign tow companies to service zones, and the assigned company uses their designated storage facility, which may be located wherever their operations are based. Distance from the tow location is determined by where the contractor operates, not by where would be most convenient for the vehicle owner. Private tow operators use their own company's storage facility, and the location of that facility reflects where the company has their secured lot, which was not chosen in consultation with any particular vehicle owner's home address or schedule. State towing regulations typically require that vehicle owners be provided with the name, address, and phone number of the storage facility, ensuring you can locate your vehicle. But no proximity requirement is attached to those disclosure provisions because these statutes were written around finding your car, not minimizing your inconvenience in retrieving it. Vehicle owners who face unusually distant impound situations do have some regulatory recourse in states that have enacted local storage requirements, but those provisions define local broadly enough that most tows comply without adjustment. The impound lot is where the operator stores vehicles. It is not a courtesy location selected for your convenience. The distance is just a longer ride. 44. You were going to move it. You had every intention of moving it. The move was imminent when the hook went on, and you want credit for the intention that the operator interrupted before it could be executed, as though the thought of compliance and the act of compliance are equivalent things deserving equivalent treatment. Parking enforcement operates on current vehicle status, not declared future intentions, which means the violation exists now, the work order exists now, and the plan to move it later is not a fact that has any legal standing in the present tense, where all enforcement decisions are made. Intention is one of the least enforceable concepts in regulatory law, and if a stated plan to comply had legal force, every driver in every violation scenario could claim they were about to move, which would make every parking restriction completely unenforceable the moment a driver became aware of an impending consequence. Most states address the specific scenario where the vehicle owner arrives during the hookup process through a defined drop fee provision, a capped charge the operator can collect if the vehicle has not yet left the property, and that is the legal mechanism for exactly this situation, designed precisely because I was just about to leave is not a workable standard for real-world enforcement. Traffic enforcement does not accept I was going to slow down as a defense, building code enforcement does not accept I was going to fix it, and parking enforcement does not accept I was going to move it, because all three operate on the same principle that stated intentions do not substitute for actual compliance in any regulatory context. Operators who delay based on driver claims of imminent departure frequently discover that the departure timeline expands indefinitely once the driver believes the threat has been neutralized, which is why operators are trained to complete work orders rather than negotiate with future tense promises. The drop fee exists for this moment. It is the legal way to turn I was leaving anyway into an actual departure. 45. There were no signs in that lot, none at all. You walked through the entire thing specifically looking for signage and found nothing, and you were presenting the absence of visible signs as conclusive proof that no tow authority existed, and the tow was therefore conducted without legal basis. Most states with private property towing statutes require specific signage at lot entrances as a precondition for tow authority. Minimum sign dimensions, required content including the tow company's name and 24-hour contact number, and defined placement height are all specified. And meeting those requirements is what validates the tow, which means the operator has a strong financial and regulatory incentive to make sure the signs were there and documentable before they ever enter the lot. No signs anywhere is factually inaccurate in the overwhelming majority of contested tow cases, which is why operators photograph signage as part of their standard pre-tow documentation protocol. Those photographs routinely show signs that the vehicle owner missed, did not see while approaching from a specific direction, or is now claiming did not exist because the claim is easier than the alternative. Legitimate no-sign challenges do succeed in administrative hearings when the facts support them. Cases where the tow company cannot produce evidence of adequate signage, or where the property owner failed to maintain required signs to the specified standard, have resulted in fee waivers and ordered returns, because the procedural protection exists and the process enforces it when the evidence supports the claim. Some property types, active construction sites, emergency no parking zones, police-ordered clearances, operate under different or reduced signage requirements because the public hazard or emergency authority supersedes the standard consumer notice framework, which means the absence of a standard tow sign in those contexts is intentional and legal. The claim that there were no signs is either wrong, in which case the photographs will establish that, or correct, in which case you have a real hearing argument. Either way, the hearing office is the right room for this conversation. 46. You came to the impound lot immediately, within hours, as fast as was logistically possible, given that you had to find out where your car was, arrange transportation, and get here. And you believe that the speed of your response should result in a storage fee of 0 because you were not actually storing the vehicle. You were just briefly separated from it against your will. Storage fees begin accruing when the vehicle arrives at the impound lot, and the speed of the owner's response affects how many daily periods accumulate, but does not eliminate the base storage charge for the period the vehicle occupied the secured facility because the lot was providing a service, secured, insured, managed storage. From the moment the vehicle was intake processed, regardless of what the owner was doing during that time. Impound lot storage fees are typically charged in daily increments starting from intake, and most states define the first 24 hours as a single chargeable unit, meaning same-day retrieval almost universally incurs at least one storage period regardless of how quickly the owner arrived after learning about the tow. The "I came right away" claim often arrives alongside the "I did not know immediately" reality, and the gap between when the tow occurred and when the owner became aware is the interval during which the storage meter was running without the owner being able to do anything about it. A frustrating reality that does not change the math. After-hours retrieval compounds the situation in a particularly visible way. Lots that are not staffed around the clock may not allow retrieval until the next business day, during which time storage fees continue accruing regardless of the owner's readiness and willingness to retrieve the vehicle immediately. Some states have enacted first-day storage fee waivers for same-day retrieval as a specific consumer protection provision, but these are codified exceptions in specific jurisdictions, not universal rights assumed to exist everywhere by default. Hotel checkout is at 11, you are being charged for the night either way. 47, you are filming the tow on your phone, you have announced your platform size, and you are operating under the belief that the combination of a running camera and a significant follower count creates either a legal deterrent or a public relations consequence severe enough to cause the operator to stop what they are doing and make a different professional decision. Filming a tow is a protected First Amendment activity in public spaces and changes nothing about the parking violation, the work order, or the operator's legal obligation to complete the removal, because the right to film and the right to park in a fire lane are two entirely separate legal questions, and one being protected does not extend its protection to the other. The First Amendment protects recording police and public officials performing their duties in public spaces, a right affirmed in multiple federal circuit court decisions, and it does not create a tow exemption any more than it creates a speed limit exemption for anyone who films themselves driving. Press credentials issued by news organizations or government agencies grant access privileges in specific defined contexts, press conferences, restricted emergency perimeters. And they do not grant parking accommodations in commercial lots, fire lanes, or tow-away zones in any jurisdiction that has been studied. Content creator status is not a legally recognized professional classification with attached regulatory privileges in any U.S. framework relevant to parking or towing, which means the size of your audience is information the parking sign did not consider when it was installed. The camera as deterrent strategy is well known to tow operators, and many companies now actively encourage their operators to assume they are being filmed during every enforcement interaction as a professionalism standard, meaning the camera you are holding has become a training prompt rather than a threat. Videos of dramatic tow encounters are a documented social media genre, and they almost uniformly show the same outcome. Filming the tow does not stop it, it just creates a video where your car gets towed while you explain why it should not be. 48. You looked up the tow company online and could not find a license, which you believe constitutes evidence that the company is operating without authorization, and you are presenting that research conclusion as though it changes what is currently happening to your vehicle. Tow company licensing is publicly verifiable through state agency databases, but the verification process requires specific search parameters: company name, license number, or registered agent. And the absence of an instant result from a general web search does not constitute evidence of unlicensed operation, because most state licensing databases are not optimized for the casual Google search you conducted while a tow truck was in front of you. Many tow companies operate under a parent company name or a registered DBA that differs from the name on the truck's logo or the name the operator gave you, which means searching the visible name may not return the licensed entity. A mismatch that reflects business naming conventions, not regulatory evasion. License plates, US.T numbers for commercial operators, and state tow license numbers are required to be displayed on the tow truck itself in most states, which means the verification information you are looking for was on the vehicle the entire time in a format designed for exactly this purpose, not for a phone search conducted at the point of frustration. Unlicensed towing is a legitimate regulatory concern that does occur, and complaints about unlicensed operators are investigated by state licensing authorities, and can result in significant penalties, including criminal charges depending on the jurisdiction, which is why the complaint process exists and why it produces outcomes when the evidence supports the claim. A vehicle owner who genuinely believes they were towed by an unlicensed operator has a viable administrative complaint that can result in fee, refund, and operator penalty. But that process requires documentation and a formal filing, not a declaration made in a parking lot based on an incomplete phone search. I checked online and could not find your license. Is homework you did not finish. Bring the evidence to the right office. 49. Your neighbor told you it was fine to park there. You have a relationship with someone who has some connection to this property, and you made a parking decision based on that social authorization without going through any formal channel that would have made that authorization real. Parking permissions are granted through formal systems, permits, assigned spaces, written management approvals, contractual arrangements. And a verbal neighbor agreement has no legal standing against a tow company operating under a property management contract, because the tow company's authority comes from the property owner or management company, not from individual residents who cannot amend that contract through casual conversation. In multi-tenant properties, including apartment complexes, condominium buildings, and shared commercial facilities, parking rules are typically enforced by the property management company or HOA under authority granted through lease agreements, and individual tenants cannot grant parking rights to outside visitors beyond whatever the management has formally authorized. The tenant does not own the space and therefore cannot give away access to it. The tow company's contract is with the property owner or management company, and a tenant's verbal agreement does not appear in that contract, cannot modify it, and does not create any instruction the tow operator is obligated to follow. In HOA-managed communities, parking rule enforcement is one of the most common sources of resident conflict, precisely because individual members believe they can grant informal permissions that the association's governing documents do not authorize, and courts consistently uphold HOA enforcement authority over individual member-to-neighbor permissions, regardless of how reasonable those arrangements seemed at the time. The legitimate version of the permission your neighbor tried to give you is a formally issued guest parking permit, a management-approved temporary authorization, or a designated visitor space, all of which exists specifically to accommodate genuine guest needs through a process that actually works. Your neighbor can give you a great many things. They cannot give you a parking space that does not belong to them. 50. You have a medical appointment, a family situation, a work deadline, or some other urgent circumstance that you are characterizing as an emergency, and you believe that the urgency of your personal situation creates an obligation for the operator to halt the removal so that you can address the more pressing matter without also dealing with this one simultaneously. Personal emergencies are real, and they are not legal overrides of tow authority, and the process for handling a genuine emergency situation during a tow is specific and narrow, and almost never the conversation the driver believes they are initiating when they use the word emergency. Emergency in a legal towing context has a narrow operational definition involving a vehicle parked because the driver became medically incapacitated, or a mechanical failure with no safe alternative supported by documentation, a scheduled appointment that ran long, a childcare situation that developed unexpectedly, or a work crisis that requires immediate attention are not emergencies under this standard, regardless of how urgent they feel from inside the experience. Tow operators who encounter drivers claiming genuine medical distress are trained to call emergency services if the situation appears to be a health crisis. The appropriate response to a medical emergency is medical assistance, not a parking accommodation, and those are two entirely different systems designed for two entirely different problems. The drop fee provision addresses the most practical version of this scenario. The driver arrives during hookup, explains the time pressure, pays the drop fee, and retrieves the vehicle. And that process exists specifically so that urgent situations have a financial mechanism for resolution rather than an honor system that operators cannot realistically administer. Emergency declarations as tow-stopping tactics are common enough that operators treat them with significant professional skepticism, not because urgent situations do not happen, but because the claim is used far more frequently as a delay tactic than as a genuine description of what is occurring. If it is a real emergency, the ambulance was already called. If the emergency is that you are late for something, that is just Tuesday. 51, it is raining, or it is dark, or there is snow on the ground, or some combination of atmospheric conditions is present that you feel should create an operational pause in towing activity. A kind of meteorological grace period during which enforcement is suspended because the conditions make the whole enterprise feel unreasonable. Towing operates around the clock, 365 days a year, in all weather conditions that produce precipitation, reduced visibility, or uncomfortable temperatures because vehicles park illegally in all of those conditions. And emergency clearance needs do not pause to wait for better weather before becoming urgent. Police-initiated emergency tows during snow events are among the most time-sensitive removal scenarios in the entire industry. When cities declare snow emergencies, towing is activated specifically to clear routes for plows and emergency vehicles, which means snow does not pause towing, it escalates the need for it and increases the volume of removals happening simultaneously. Nighttime towing is a standard operational category that generates some of the industry's highest volumes because overnight. Parking restrictions in residential areas, late-night commercial district enforcement, and apartment complex patrol all produce peak violation rates between 10 at night and 3 in the morning, when the combination of low visibility and reduced observer presence means violations accumulate faster than during daylight hours. Rain and reduced visibility are occupational conditions that tow operators are trained and equipped for, with commercial vehicles carrying professional lighting systems, safety equipment, and reflective markings specifically designed for adverse conditions. The operator's working environment and the vehicle's legal status are entirely separate considerations operating on separate regulatory tracks. The rain did not move your car into the restricted zone. The dark did not park it in the fire lane. Whatever conditions existed when you made the parking decision still exist when the hook goes on, and the weather has never once testified on anyone's behalf at an administrative hearing. 52. You just bought the car, the title is not transferred yet, the paperwork is somewhere in the process between the previous owner and the DMV. And you believe this administrative gap creates a legal gray area that makes the vehicle's current parking situation someone else's problem, or at least a less clearly defined version of your problem. Title transfer timelines create a grace period for operating the vehicle on public roads with a bill of sale while the paperwork processes, and that grace period relates to registration and title administration. It does not create immunity from parking enforcement because the vehicle is in your physical custody, operating under your control, and subject to all applicable road and parking regulations regardless of where the title document is in the transfer queue. State DMV rules allow a defined period, typically 10 to 30 days depending on jurisdiction, for completing title transfer after a vehicle purchase, during which the vehicle can be legally operated with documentation of the sale, and that provision was designed to accommodate the administrative reality of transfer processing times, not to create a temporary suspension of the buyer's obligation to follow parking rules. Law enforcement and tow operators do not require title confirmation before enforcing parking violations, because enforcement is based on the vehicle's physical status in its physical location, not on who the DMV database currently identifies as the registered owner in a transaction that has not yet been processed. A newly purchased vehicle displaying temporary tags or no tags is in some jurisdictions a higher enforcement priority rather than a lower one, because unregistered vehicles are harder to trace and more likely to meet the criteria for abandoned vehicle removal under statutes designed for exactly that scenario. The vehicle's owner of record, the previous owner, if the transfer has not cleared, will receive the statutory tow notification, creating complications for both parties that are entirely avoidable by completing the transfer through the normal DMV process without delay. The car is yours the moment you drive it off the lot, including every rule that comes with it. 53. The meter was broken. You noticed it was not functioning when you arrived. You reported it to the appropriate city number. You have a record of the report, and you believe that this chain of responsible civic behavior creates an authorization to park at that location for as long as your errand requires without any enforcement consequence. Most cities with metered parking have a defined broken meter policy that provides a specific limited grace period at the malfunctioning meter, typically equivalent to the posted maximum time limit for that space. And that grace period is not unlimited parking, is not a tow exemption, and does not extend to spaces or zones governed by restrictions that operate independently of the meter payment system. Reporting a broken meter is a city maintenance request that generates a repair ticket, and it is not a parking permit, an authorization document, a tow waiver, or any kind of official communication between you and the city about your specific vehicle's status at that location on that day. Cities that have transitioned to smart meters and app-based payment systems have largely eliminated the broken meter problem as a practical matter by providing alternative payment mechanisms that function regardless of any specific meter unit's operational status. Meaning the driver's obligation to pay has not disappeared, just the specific hardware that used to be the only way to fulfill it. Tow-away designations at specific locations operate independently of the meter system, which means a space with a functioning 2-hour meter inside a street sweeping corridor still gets towed during the sweeping window, and the same is true when the meter is broken, because the sweeping restriction and the meter are administered by different systems that do not communicate with each other about individual vehicles. The "I reported it" element does add a paper trail that may be useful in an administrative hearing if your city has a broken meter accommodation policy and the timing and location match. But the hearing office is where that argument belongs. Reporting a broken meter is responsible, it is not a coupon. 54. You have a letter from your doctor, or you have documentation of a medical situation, or you have some form of written communication from a healthcare provider that you are presenting as a parking accommodation that should cause the operator to release your vehicle without completing the removal. Physician notes are not parking permits, and the accommodation for medical parking needs in every state is a formally issued disabled parking placard, an advanced administrative determination made by a state agency after reviewing physician certification, which is a document the physician's note may eventually support through an application process but does not itself constitute or replace. Disabled parking placards require an application to the state DMV supported by physician certification of the qualifying condition, and the physician's role in that process is to certify eligibility so that the state can issue a formal permit. The doctor's authority ends at the certification, and the permit authority belongs to the DMV. Which is why a note without a placard is a step in a process rather than a completed one. A physician note presented to a tow operator in a parking lot has no legal standing because the operator is not a DMV adjudicator, has no authority to evaluate medical claims against regulatory criteria, and has no mechanism to honor informal medical documentation as a substitute for the formal permit the accommodation system requires. Medical facilities with significant patient populations almost universally provide patient parking accommodations, valet services, short-term loading zones, designated patient spaces, specifically to address the proximity need for patients with mobility limitations because those facilities are required under the AD to provide adequate accessible parking as a condition of operation, which means the legitimate accommodation already exists in the correct location. Temporary disability placard programs exist in most states for short-term medical conditions, providing time-limited accommodations through the proper administrative channel for exactly the situation you are describing. Your doctor can write a note for a great many things. A parking permit is not one of them. That document comes from the DMV. 55. You got your car back, you looked at the tow truck's path, and you have decided that the proximity of heavy equipment to your vehicle during the hookup process constitutes a damage event, even though what you are describing is a large truck being near your car, rather than a large truck making contact with it. Tow truck operators are trained in spatial positioning for hookup operations, placing the truck to access the vehicle safely while minimizing interaction with adjacent property, and that positioning is a practiced professional skill developed over thousands of hookups rather than a random parking decision made by someone who does not care about what they hit. The claim that the tow truck being near your car caused damage requires physical evidence of contact, paint transfer, matching impact patterns, or contemporaneous documentation of the moment of contact. and none of those things are produced by the truck simply occupying the space near your vehicle while the operator worked. Pre-tow photo documentation captures surrounding vehicles and their condition before anything moves, which provides a baseline that makes post-tow adjacent damage claims exceptionally difficult to substantiate when the photographs show what the panel looked like before the operator arrived. The concept of proximity as a damage mechanism is logically strained because if the tow truck's presence blocked access to your vehicle was not moving, and stationary vehicles are not damaged by the presence of other stationary vehicles in adjacent spaces regardless of their size. Legitimate contact damage claims do occur when a tow truck's maneuver makes actual physical contact with a nearby vehicle, and those claims are covered under the operator's commercial liability insurance through a documented process that works when the evidence supports it. A tow truck being near your car is not a physical event that produces damage. Proximity is not collision. If there is a mark, there is a history, and the pre-tow photographs know exactly how old it is. 56, you want a receipt right now, at this moment, in the parking lot, before the vehicle has been transported anywhere, and you believe the operator's inability or unwillingness to produce complete billing documentation on the spot is a procedural failure that creates grounds for contesting the tow or demanding immediate release. Receipt and documentation requirements in towing apply to the impound lot at the time of vehicle release. That is the legally significant moment, the transaction point, the place where fees are established, payment is collected, and documentation is required to be provided, and not to the hookup operator in the field who is completing the first half of a two-part process. State towing regulations require that vehicle owners be provided with documentation of the tow, including the company's name, contact information, and impound location. But the delivery mechanism and timing vary by jurisdiction, and the primary notification mechanism in most states is a police database posting required within 1 to 2 hours of the tow, not a paper receipt handed to whoever happens to be standing nearby. Hookup operators who work for dispatch operations frequently do not have complete billing information at the time of tow because the final fee is determined by the lot based on tow type, vehicle classification, time of intake, and applicable storage, making a complete itemized receipt at the moment of hookup not just withheld, but genuinely impossible to produce accurately. Operators are typically required to leave a notice at the tow site, a sticker or posted notice at the vehicle's last known location, specifically to inform the owner of where the vehicle went before they resort to calling police to find it. The receipt lives at the impound window with the keys at the end of the process that is currently in its beginning stages. That is where the paperwork is. That is where you are going next. 57, someone told you, or you read somewhere, or you have a strong feeling based on accumulated cultural information that private property towing has been made illegal in your state, and you are presenting this as established legal fact to an operator who is licensed by that same state and contracted by a property owner who operates within it. Every state in the United States has a legal framework authorizing non-consent towing from private property, all 50 of them, without exception. And no state has prohibited the practice because property owners have a legally recognized right to control access to and use of their land that predates the towing industry and does not disappear because the practice is inconvenient. What varies enormously between states is how private property towing is regulated. Signage requirements, fee caps, payment method mandates, drop fee provisions, retrieval rights, and notification timelines all differ significantly. And the confusion between heavy regulation and prohibition is where the myth lives, in the gap between they tightened the rules significantly and they banned it entirely. Some states have enacted comprehensive reforms in response to documented abuse, Texas being a prominent example after high-profile predatory towing scandals in Houston and Dallas in the mid-2000s. And those reforms strengthened consumer protection substantially without removing the property owner's underlying right to authorize tow enforcement on their property. Online posts claiming specific states have banned and private towing circulate with enough frequency and confidence to feel authoritative, and they are almost uniformly false, typically mischaracterizing a specific reform provision as a prohibition because the distinction requires more legal context than a shareable post usually provides. Drivers who believe their state has banned private property towing can verify the actual current law through their state DMV or Public Utilities Commission website in approximately 4 minutes. The tow company operating in your state with a state-issued license has already done that research. The answer has not changed. 58. Your vehicle has a boot on it from a prior enforcement action, and you believe that the presence of the boot creates a jurisdictional barrier that prevents a tow company from also removing the vehicle, as though the boot establishes an exclusive claim that blocks any other enforcement mechanism from operating simultaneously or subsequently. Boots and tows are different enforcement mechanisms that can operate sequentially within the same enforcement framework, and a vehicle with an outstanding boot may be towed rather than remaining indefinitely immobilized if the boot fee is not paid within the defined response window. Because towing is frequently the escalation step that follows failed immobilization rather than a competing action that conflicts with it. In many cities, booting and towing are deliberately structured as sequential escalation steps for the same class of violations: outstanding parking citations, registration delinquency, permit violations, where the boot gives the driver a reversible opportunity to pay and leave, and the tow replaces the boot when that opportunity is not used within the specified period. The physical presence of a boot does not create an ownership interest or exclusive jurisdiction in the booting authority. It creates a lien against the vehicle, and a lien does not prevent another authorized enforcement action by a different party operating under separate authority on a separate legal basis. In private lot scenarios, a property manager may deliberately use a two-stage enforcement approach, booting first as a recoverable action, escalating to towing if the vehicle remains, which is a considered enforcement design, not a procedural conflict between two incompatible systems. Removing a boot without authorization is typically a criminal offense involving destruction of a lawful lien or interference with an enforcement action, which means a driver who removes the boot to avoid the tow may be creating criminal exposure on top of the underlying violations that started the sequence. The boot means someone got there first. The tow means they ran out of patience. These are stages, not competitors. 59. You have opinions about your transmission, you have knowledge of your drivetrain configuration, and you are delivering a technical briefing to the tow operator about the specific handling requirements of your vehicle's powertrain that you believe they were not previously aware of, and that changes what they are permitted to do. Managing vehicle drivetrain configuration for safe towing is a core technical component of tow operator certification, not a gap in their training that you are helpfully filling with information from your owner's manual and the protocols for handling automatic transmissions. Manual transmissions, all-wheel drive systems, and electric powertrains are part of the curriculum operators completed before they were licensed to do this work. Tow operators are trained on drivetrain management for every common vehicle type, including when to place vehicles in neutral, when to use dollies to lift drive wheels to prevent transfer case rotation, and when flatbed transport is required to avoid powertrain damage. Because drivetrain damage claims create liability for the operator, giving the industry a strong financial incentive to handle this correctly without your guidance. The industry shift toward flatbed towing as the standard for most vehicle types in urban markets was specifically driven by awareness of the drivetrain damage risks associated with traditional hook and chain methods, and that equipment evolution reflects exactly the technical knowledge you are attempting to provide as though it is new information. Vehicle manufacturers publish towing specifications for their vehicles, neutral requirements, drive wheel lift requirements, maximum tow speeds, and professional operators reference those specifications for unusual or unfamiliar configurations because the information is available and the liability for ignoring it is real. Vehicle tampering in a criminal or civil context refers to unauthorized alteration of a vehicle's systems to impair its function or value. Placing a transmission in neutral to facilitate a safe legal tow is an authorized operational action under tow law, which is definitionally outside that category. The operator has moved more transmissions this week than you have in total. The car is being handled correctly. 60. Your dog is in the car. You are invoking this fact with appropriate urgency, and you believe that the combination of an animal's presence and your emotional investment in that animal's well-being creates a legal or ethical barrier to the vehicle's removal that a reasonable person could not proceed past without acknowledging. An animal in a vehicle is a welfare concern that triggers specific protocols. It is also not a tow exemption, and the presence of the animal in the vehicle is a direct consequence of the owner's decision to leave it there, which means the welfare concern and the parking violation were created by the same person at the same moment. Most state animal welfare statutes prohibit leaving an animal in a vehicle under conditions that endanger its health or safety, which means the owner who left a dog in a car that is now being towed may simultaneously be in violation of animal welfare law and parking law, a combination that adds to the regulatory situation rather than reducing it. Tow operators who discover an animal in a vehicle during a hookup are trained to contact animal control or police before completing the removal, not to stop the tow, but to ensure that a coordinated welfare response is in place before the vehicle arrives at the impound lot where the animal will need to be managed. Animals in towed vehicles are transported with the vehicle to the impound facility where lot protocols for animal presence apply. Many facilities have established procedures for animal holding and owner notification specifically because this scenario occurs with enough regularity to require a standard response. The legal principle at the center of this situation is that the animal's presence in the car is a consequence of the owner's choices, not a condition that transfers responsibility to the tow operator for the welfare outcome. Your dog did not choose that parking spot, you did. Animal control handles one of those decisions, the tow handles the other. 61. You want an apology, not a fee reduction, not a vehicle release, not a procedural correction. An actual acknowledgement from the tow company that what happened was wrong and that they are sorry it occurred, and you are prepared to make the absence of that apology a separate grievance on top of everything else. Apology is a social gesture that implies fault, and when a tow is conducted lawfully on a vehicle that was in violation, there is no fault to imply. Which means expecting an apology for correct enforcement is expecting someone to claim responsibility for your parking decision, and no professional in any enforcement context is trained to do that. In legal and insurance contexts, apologies are carefully managed communications because they can be interpreted as admissions of liability, and tow companies operating under commercial contracts and carrying commercial liability insurance have legal counsel who explicitly instruct operators not to apologize for lawful tows, a policy that serves the company's legal interests and also accurately reflects the factual absence of anything to apologize for. Customer service in enforcement industries occupies a specific professional space where the person being served is simultaneously the subject of an enforcement action, and operators who over-apologize in that context create confusion about whether the tow was valid, a confusion that costs the company and helps no one. Some impound lot staff do express sympathy for the difficulty of the situation. I understand this is frustrating as a communication practice, and that is a professional choice about tone, not an acknowledgement of error, and it changes none of the fees or the process. The distinction between "I am sorry this happened to you" as an expression of empathy and "I am sorry we did this to you" as an admission of fault is exactly the line tow industry professionals are trained to maintain. An apology would mean they did something wrong. Moving your car from where you were not allowed to put it is not that. 62. You drive an electric vehicle, you have informed the operator of this, and you are describing battery management concerns with enough technical authority that you are hoping the conversation itself will consume enough time and introduce enough uncertainty that the outcome changes. Electric vehicle towing does require specific protocols, primarily flatbed transport rather than wheel lift or dolly methods, because EV drivetrains generate electricity through regenerative braking when wheels rotate, a process that can create issues in the battery management system if the motor spins without the vehicle's control software active to manage it. The requirement for flatbed transport is not a tow prohibition. It is an equipment specification, and flatbed towing is already the industry standard for a wide range of vehicle types in urban markets, meaning the method your manufacturer recommends is already the default approach for the category of tow being performed on your vehicle right now. Tesla, General Motors, Rivian, Ford, and other major EV manufacturers publish towing guides for their vehicles that are publicly available, and professional operators in urban markets where EV ownership is significant reference those specifications because the liability for improper handling is real and the information is accessible. EV-specific towing training has become increasingly standard across the industry as electric vehicles have grown as a share of the vehicle population, and operators working commercial lots in markets with high EV density have adapted their equipment selection and handling protocols accordingly without requiring a separate specialist certification for each brand. The charging-related considerations that arise during impound, low battery during storage, charging access at the facility, are an emerging operational issue the industry is actively addressing through protocol development, and they are separate from whether the tow itself was lawful or properly executed. Your EV gets towed on a flatbed, the flatbed is already there. The protocol your manual specifies is the protocol being used. Your battery is fine. 63, you know the operator's boss, or you know someone who knows the operator's boss, and you are invoking that connection with the expectation that the social network you are describing will cause the operator to calculate the professional risk of completing a lawful work order and arrive at a different decision. Tow operators work under documented work orders, and completing a documented lawful work order is not a fireable professional offense. Abandoning it without authorization is, because the operator's company is under contract to perform the service, and failing to perform it creates liability toward the property owner or municipality that contracted for enforcement. The "I know your boss" invocation is among the most frequently heard and least consequential threats in the towing industry, encountered by experienced operators dozens of times per month across their career, which means the company owner has received more calls about this threat than the operator has received calls about anything. Tow company owners and managers who receive calls from people claiming personal connections as leverage against their operators' enforcement decisions are trained to respond consistently. If the tow was legal and documented, it stands because the personal connection does not appear in the contract and cannot modify the service obligation. An operator who stops a lawful tow because a driver claimed to know the boss has created a documented service failure, which runs exactly backward from the employment protection the driver believes the threat provides, and which is why the training addresses this scenario explicitly rather than leaving it to individual judgment. The threat requires 3 simultaneous conditions: that the connection is real, that the boss would override a lawful work order for a social favor, and that the call reaches the boss before the tow is complete. And all 3 must be true at the same time for the strategy to work, which is a convergence that almost never occurs. The hook is faster than the phone call. Your boss's friend is not going to make it in time. 64, your car was stolen, someone else was driving it, you were not involved in the parking decision, and you are presenting the theft as a transfer of responsibility that makes the tow fee someone else's problem and the administrative burden of the impound situation a consequence you should not have to manage. Stolen vehicle claims are a documented enforcement context with a specific separate process, and a genuine theft is a police matter that intersects with the impound system through defined statutory procedures. It is not a fee cancellation mechanism activated by verbal declaration in a parking lot. A vehicle reported stolen and subsequently found parked in a violation area is typically impounded under a different tow category, police hold or stolen vehicle recovery, which may carry different fee structures than a standard parking violation tow, and which is processed through law enforcement channels rather than standard lot administration. Stolen vehicle reports must be filed with police before the owner discovers the tow for the timeline to be credible in any subsequent review, because a report filed after the vehicle is already an impound is subject to significant skepticism from both law enforcement and administrative hearing officers who have seen the sequence before. States vary in their policies on tow fee liability for verified theft victims. Some waive fees for confirmed auto theft situations, others maintain that fees are liens against the vehicle regardless. And determining which policy applies requires knowing your state's statute rather than assuming the most favorable outcome. Law enforcement officers who respond to theft claims in the context of an impound tow conduct a basic verification process that distinguishes genuine situations from fabricated ones through timeline analysis, prior report checks, and owner interviews. A process that works and that the false claim does not survive. If your car was actually stolen, you need a police report. That report opens a separate process that handles exactly this situation. If the report does not exist yet, that is the first stop before the impound window. 65. You are filming. You have announced that you are filming, and you have now decided that the act of filming creates a legal obligation for the operator to identify themselves on camera with their full name, license number, and employer information before they are permitted to continue any enforcement activity in your presence. Identification requirements for tow operators vary by state and are not triggered by the act of being recorded. They are defined by statute, apply in specific circumstances, and require production to specific parties rather than performance for a camera at the demand of whoever is holding one. Most states require tow operators to carry their license and provide identification to regulatory officials or law enforcement upon request. Not to members of the public who have decided to film them, because those are two different legal relationships with two different sets of attendant obligations. Some states do require tow operators to provide their name and company name to the vehicle owner upon request as part of the non-consent tow consumer protection framework, and that requirement exists independently of whether anyone is filming. It applies when asked through the normal course of an enforcement interaction, not as a performance triggered by a running camera. The identify yourself on camera belief conflates law enforcement identification obligations, which vary by state and apply to specific public officials, with the obligations of private sector licensed workers, whose identification duties are defined separately and more narrowly by occupational licensing law rather than by constitutional provisions. Truck signage requirements in most states mandate that the company name, state license number, and U.S. DOT number be displayed on the tow vehicle itself, which means the operator's identification information was on the truck the entire time in a format accessible to anyone who looked at it rather than at their phone screen. The camera did not deputize you. Filming someone does not make them your witness, your employee, or your subject. The company name is on the door. 66. You have characterized this enforcement interaction as a hostile work environment. You have used that phrase with confidence, and you are expecting the legal weight of that terminology to produce a pause in proceedings, while the operator considers the regulatory exposure you are describing. Hostile work environment is a specific legal term under employment discrimination law that applies to employment relationships, requires conduct based on a protected characteristic, and requires a severity and pervasiveness that alters the conditions of employment. And you are not an employee of the tow company, which eliminates the foundational requirement before the analysis proceeds any further. The phrase has migrated into general conversational use as a synonym for an unpleasant or confrontational situation, which gives it the sound of legal weight it does not carry outside the specific employment discrimination context where it was developed and where it retains its defined meaning. Consumer protection claims against tow operators are available when operators engage in documented prohibited conduct, threatening behavior, physical intimidation, dishonest practices, unauthorized fees. And those claims have accurate legal names including consumer fraud, harassment, and in extreme cases assault, none of which are the same as the hostile work environment doctrine you are currently applying to a parking enforcement interaction. Tow operators themselves are subject to hostile work environment protections in their employment relationship with their company, which becomes an ironic detail when they are being screamed at in a parking lot by someone invoking that exact doctrine incorrectly while creating the conditions the doctrine was designed to address. Courts receiving hostile work environment claims in non-employment contexts dismiss them at the pleading stage for failure to state a legally cognizable claim because the threshold elements, employment relationship, protected characteristic, altered employment conditions, are simply absent when no employment relationship exists between the parties. Hostile work environment means something very specific to an employment lawyer. To a tow driver in a parking lot, it means you have run out of other arguments and switched to saying legal-sounding words at increasing volume. The tow is still happening. 67. You have concluded that towing enforcement in your area is destroying local businesses, that it constitutes an abuse of regulatory authority, and that you intend to sue the city. A threat you are delivering with the confidence of someone who has not yet spoken to a municipal attorney about what that process actually involves. Tortious interference with business relations requires an intentional and improper act directed at a specific business relationship, and uniform parking enforcement applied to all vehicles in a designated zone, regardless of the owner's commercial affiliations, is definitionally not targeted interference. It is the opposite of targeting, which is the entire legal problem with the argument. Constitutional takings claims require a deprivation of property without just compensation for a public use. And towing a vehicle from a location where it was illegally parked is an enforcement action, not a governmental seizure for public benefit. The legal distinction between those two things is well established and consistently applied in cases courts see regularly. Businesses that believe parking enforcement is reducing customer access have legitimate policy advocacy channels, city council testimony, business improvement district engagement, parking permit applications, and formal comment periods, all of which have produced policy changes in various cities through the political process that exists precisely for this kind of concern. Federal courts have consistently upheld municipal authority to regulate parking and traffic in commercial areas as a valid exercise of police powers, and a business owner who disagrees with that regulation must demonstrate a constitutional violation rather than an economic impact, because economic impact from lawful regulation is not a compensable injury under established takings doctrine. Cities have municipal law departments whose full-time professional responsibility is defending exactly these theories, and they have been doing it long enough to have standard responses to every variation of the argument you are building. You can absolutely sue the city. The city's legal department has a file for this. It is labeled ongoing and it is very thick. 68. Another car parked in the exact spot where your car was towed from immediately after your car was removed, and you watched it happen, and you have decided that the absence of an immediate second tow proves that the location is not actually an enforcement zone and that your tow was therefore selective, arbitrary, or both. Enforcement is not real-time and continuous. Tow operators patrol on schedules determined by contract type, patrol interval, and dispatch availability. And the gap between enforcement events is a function of how those factors align on a given day, not evidence that the zone is inactive or that your vehicle was targeted within it. The car that parked after yours was removed may be towed on the next patrol pass, and you will not be present to observe that outcome, which is exactly how the selective enforcement myth sustains itself. The driver who was towed observes the driver who was not, draws a conclusion about the rule's applicability, and never sees the second tow that occurred 40 minutes later when the patrol came back around. Property managers and municipalities receive complaints about uneven enforcement regularly, and the consistent response is that enforcement operates on patrol frequency rather than on a guarantee that every violation will be actioned within minutes of its occurrence, a standard that no jurisdiction has ever met or claimed to meet. Photo documentation of another vehicle in a recently cleared violation space is not evidence of improperly applied enforcement. It is documentation that a new violation has occurred, and that new violation has its own enforcement timeline that is entirely independent of what happened to your car. Selective enforcement claims in administrative proceedings require showing that a specific individual was targeted, while similarly situated individuals were deliberately not actioned. Showing that requires evidence of the operator's awareness and decision-making regarding both vehicles, not just the observation that the second driver got lucky on the patrol schedule. The speed limit exists whether the patrol car is behind you or not. 69. You are calling your lawyer. You are doing it right now. You are holding the phone up in a way that communicates the seriousness of the call that is about to happen, and you believe that the invocation of legal representation creates an immediate procedural pause in the tow process while counsel is secured and consulted. The right to legal counsel under the Sixth Amendment applies to criminal prosecutions, and a parking violation with its resulting tow is a civil and administrative matter, which means the constitutional right to counsel does not apply in the same operational way, and invoking it does not trigger any pause in proceedings the way it does in a criminal arrest context. An attorney physically present at a tow scene has no more legal authority to stop the tow than the vehicle owner does, because the authority to complete the removal comes from the work order and the underlying legal authorization, not from the absence of a lawyer. And the only mechanism through which an attorney could legally halt a tow in progress is an emergency injunction from a court, which requires a judge, a filing, documented grounds, and a time frame that does not fit in the window before the truck drives away. The threat to call a lawyer is one of the most consistently heard phrases in tow dispute contexts, and one of the most consistently ineffective ones. Operators report that it correlates with no change in tow outcome, and sometimes with the lawyer later explaining to the client what the operator already told them in the parking lot without the billable hours. Attorneys who have successfully challenged tows do so through the administrative hearing process in civil litigation. Organized, documented, evidence-based proceedings that happen after the vehicle is at the impound lot, not impromptu interventions that happen while the hook is on the car. Your lawyer is a phone call away. The hook is right there. One of those things is currently attached to your car. Call the lawyer after. That is what after is for. 70. You have determined that this tow company should not be operating in your neighborhood. You have informally surveyed the area and concluded that community consensus supports your position. And you are presenting that collective sentiment as a form of authority that supersedes the operator's contract and license. Community sentiment is a legitimate and powerful input into public policy, and it is not a source of legal authority that overrides active contracts, state-issued licenses, or individual enforcement actions. The channels through which community concern produces actual outcomes are political and regulatory, and none of them run through a parking lot confrontation with a licensed operator completing a work order. Tow companies are licensed by state agencies and contracted by property owners or municipalities, and neither of those authorizing relationships requires neighborhood approval, community board ratification, or resident consensus. The authority comes from the state and from the contracting party, and those sources did not consult the neighborhood before issuing the license or signing the contract. Community-driven towing reform has been politically effective in documented cases. Residents who organized, documented their concerns, and engaged city council processes have successfully changed municipal tow contracts, fee structures, and enforcement protocols in multiple cities, because the political process works when the pressure is directed at the institution that has the authority to respond. HOA communities and condominium associations can vote to change their parking enforcement contractor through their governance process, a real mechanism that produces real outcomes when the residents who want change engage it through the correct procedure rather than through individual confrontations that change nothing. The invocation of neighborhood consensus in a parking lot is a social pressure tactic designed to make the operator feel outnumbered, and operators who maintain enforcement consistency despite that pressure do so because inconsistent enforcement creates liability toward their contracting clients. Bring this energy to the city council meeting. The tow driver's work order did not come from a neighborhood vote. 71. You have exhausted every argument, every threat, every legal-sounding phrase, every emotional appeal, every social connection, every procedural objection, and every theory of parking law you have ever encountered, and you have arrived at your final declaration. One day, somehow, in some form, this is going to come back around, and you want the operator to know that before you leave. The vehicle was parked illegally. The tow was conducted lawfully. The documentation exists. The regulatory process is available. The administrative hearing is scheduled during business hours at an address you can look up. The fee is set by a filed rate schedule. The appeals process works when the facts support the claim. The operator completed a work order that existed before you arrived and will exist after you leave and has nothing personal about it in any direction. The "you will get yours" declaration is a documented endpoint in towing confrontations that arrives after every other argument has been tried and is recognized by operators as the signal that the confrontation is ending rather than escalating, because it is the verbal equivalent of a period at the end of a very long sentence. Tow operators who have worked enforcement routes long enough report a consistent relationship with this moment. They have heard it enough times to know exactly what it means, which is that you have run out of content and need a closing statement with some emotional weight to it. The implicit theory that enforcing a parking rule creates a karmic debt is built on the premise that the enforcement was wrong, and the legal framework, the documentation, and the violation record collectively contradict that premise before the theory even gets started. Karma does not give cars back. Administrative hearings do when you have grounds. Courts do when you have evidence. Pay the fee, contest the tow through the right channel, and save the prophecy for someone with the time to hear it out. If you want to see more, click the video on screen now.